Good morning. Good morning. Good morning. I have coffee. I have some cases that are going to make us all use the cursey words. We kind of needed a break from everything we've been covering, and I am in the middle of the rabbit hole with regard to ChatGPT and these lawyers in New York. They filed like 6 new things before their hearing in New York today. I am not in New York today. If you've seen the apocalypse scape that is New York, you might understand why I didn't hop on a plane this morning and go to New York. I'm here with you instead. The Supreme Court ruled in the Jack Daniels Bad Spaniels case, and we're going to talk about that too. And of course, last night was the third part of the Vanderpump Rules reunion. I have thoughts because, we talk about pop culture here. Look, there was a restraining order. It was legally adjacent. So we talked about it too. Yesterday, I had the most delightful phone call with Rick Hogue, and he was like, talk to me about Scandival. And I was like, oh my God, Rick, I thought you would never ask. Let me tell you everything about Scandival. So that was absolutely fantastic. We had a really nice chat about that yesterday. So it's time to get rolling, but Replay crew, as always, absolutely love you. Let me know where you're coming in from and what you are drinking. It is going to be a day. We're going to just talk about cases that, though they have consequence, aren't as heavy as some of the cases we've been talking about. Just a reminder, if you have not caught up on this week's podcast, you don't want to miss that. If you haven't caught up on Quick Bits this week, you don't want to miss that. And with that, we're going to roll the intro. We're going to chat about the things. We're going to do a quick bit that's not a real quick bit, and then we're going to just get into it. So timestamps, as always, are down below. Let's roll, Law Nerds. Let's go. It's time. We're kind of on time, so we need to just embrace it.
Hey there, I'm Emily D. Baker, the internet's go-to legal analyst, breaking down the legal side of the pop culture and entertainment stories we can't stop talking about. I'm a big fan of the cursey words. I've been a licensed attorney for over 17 years, but this is not legal advice. This is where the law nerds unite to talk about facts, not... Let's get into it.
Tiny Dragon is asking the questions we all want to know. Is a throuple a legal agreement? I don't think a throuple has to be a legal agreement, but I think a throuple can be a legal agreement. And if some of you are like, Emily, what is that word coming out of your mouth? It's like a couple, but with three. So throuple. So last night we're just gonna have to chat about it for a minute. So last night was the third part of the Vanderpump Rules reunion. For those of you that are non-Bravo, I think there are probably some of you that are non-Bravo, but maybe few of you that are non-Bravo. For those of you that know the Bravo sphere, there's always a reunion with Andy Cohen where he sits down with the cast and dissects what happened in the previous season, and there's generally a lot of yelling. Sometimes there's not. Sometimes the air gets cleared. Sometimes you learn new things and the things that have happened since the time that the show has aired, and the cast has finished all of their behind the scenes interviews, and then there's a reunion and Andy Cohen asks questions. I wanted to cross-examine everything that happened last night so badly. I'm like, you said this exactly, what about this? You said that exactly, what about this? So we got the reunion. Tom Sandoval made a dig at Ariana about being intimate with her t-shirt on and how very sexy it was. Ariana responded in the only and best way possible. And I'm going to show you that in a minute. But it was hilarious. But you could see Andy Cohen's face was just like, I can't believe. I can believe you thought that, but I can't believe that came the fuck out of your mouth. How did that come out of your mouth? And then you saw Tom Schwartz, who said blessedly little this entire reunion, go, you can't say that, man. And we also know that Ariana has been very open on the show about body image and how she views herself. She's a stunning woman, absolutely a stunning woman. And you can see him just going for the low blow to hurt her, which I think is why it's so offensive to me. It's not the shirt. It's not the this. It was he was trying to hurt her about her body and trying to dig at her in the, you know, sort of a I cheated on you because like you're not sexy enough. That's how I took it in the trying to hurt her. So that's why I was just so like, oh, this is trying to specifically hurt her. And that's why it was just so wild. And then you see, you know, Raquel, Rachel have some kind of an awareness, and then sits down a few days after the reunion for an interview, which is unusual that they air post-interview conversations with just one cast member. Like they just broke all of the rules on this one, and it was kind of fun to see. But this was supposed to be a big reveal. I feel lied to. We should sue Bravo. They breached their contract because Bravo producers said they don't want the cast to re-sign for season 11 until they see this reveal in the last 5 minutes. You don't want to miss the last 5 minutes of Vanderpump Rules because there is a reveal that is so shocking. The affair has been going on longer. Okay. Everyone knew that. Everyone knew that. Everyone, not everyone, most. We sat through all the fucking commercials to get to the end of it's been going on for longer. Are you fucking kidding me? The interwebs knew this. This was not shocking. It was not a big reveal. It was, I think the biggest reveal in the big reveal was that Raquel had emotion. I feel lied to. My husband, Sheila said it in the chat, all of the Ariana commercials. My husband was like, is she in every commercial? Yes. Yes, she is. Did you guys see her Duracell batteries commercial? Because Tom made it, every company that can capitalize on Scandival is capitalizing on Scandival. Everyone. And so Tom was making a whole like, she doesn't even buy batteries. We have batteries and paper towels in the house because I buy them. Tom, my God, you live in a house. Oh my God, are we supposed to congratulate men because they live in a house and they buy things that go in the house? No, you live in the house too. Buy toilet paper when you go to the store. You don't get a fucking gold star for existing as an adult. Good God. So he's like, I buy batteries. It's so hard for me. Shut the fuck up, Tom. So Ariana has a great commercial with Duracell where she takes white nail polish and like chucks it. She's like, I'm done with everything basic, but I am using Duracell. And then in the comments on social media, one of the brands of paper towels is in there like, oh, so this is what we're doing now? Duracell's official account responds, your move. It's fucking hilarious. Fucking hilarious. So all of the companies that can tie in to things that Tom has said are taking the opportunity to poke at the things Tom has said and to put Ariana in commercials and to just kind of celebrate the cheekiness. And it's been really fun. Stina, yes, there was a closet of paper towels stacked. It's just kind of cheeky. And now she probably has batteries for life. And the cheekiness has been funny. And she's leaned into all of the cheekiness. Because why not? Go off, girl. Get your coin. Because then if she chooses in a year to not be on reality TV, if she's just done with all of this, she's setting herself up to allow herself to be done. And I'm here for it. Here for all of it. Get it. Get it. Get it. Get it. Get it. Get all the commercials. Get the covers of all the magazines. Do it. There's times when she clapped back at Tom and I was like, that's everything I've ever wanted to say to somebody that's hurt me. It's kind of cathartic to watch somebody else get to do it on television. And you can't write it. So I'm here for it. So when Tom made the Tom made the hashtag not sponsored because I guess I should say that. Oh, Emily, why is your screen not shared? You knew you were going to share things. That might be why she wanted the batteries, chat. This might be why she needs all the batteries. Chad is making all of the appropriate jokes about where Ariana should put those batteries. Get it, girl. Where's the sponsorship with Adam and Eve? Because she'll be much happier, I'm sure. All right. Did I watch the extended version? Not yet. I've not yet watched the extended version, but I did want to share that this is how one of the ways Ariana has capitalized on this. This is a t-shirt being sold at Something About Her, which is the sandwich shop she's opening with Katie. And it says, though you can hardly see it, I want this shirt in black so bad. It says, fuck me in this t-shirt. This is the merch. This is the merch. This is the merch moment. Get it. With the fucking sandwich. Go. It's pretty everything. It's pretty everything. So this is at somethingabouther.com on their Shopify store. It's pretty funny. It's it's just pretty funny. Jody's like, with the grilled cheese. Yes. Yes. It's a whole mood. It's just so as Tom takes a dig at her on stage about her having sex with her t-shirt on or whatever and it not being very sexy, she releases a shirt with her business partner, who is Tom's, for those of you that don't Bravo or don't VPR, Tom and Tom are best friends. Ariana and Katie are opening a sandwich shop. Tom Scandival is Ariana's ex. Tom Schwartz is Katie's ex. So these two are getting ready to just blow up their business as well. So get it? I like it. Bravo should have brought you in to cross Tom and Rachel. Knit One, Law 2, I agree, but that's not their style. I could do a mock cross-examination of me just the question I would ask after their answers. So that's a little bit of my thoughts. The shirts are going to sell a ton. I imagine everyone at BravoCon is going to be wearing these shirts. It's kind of funny. The crew at VPR has next leveled their merch game. They're giving very, very wise social media stars. The housewives don't do it quite as well as the VPR crew. The VPR crew, they have their merch game on point. There was just an article about Lala paying for the down payment in her house with the Send It to Daryl merch because she turned it around in a day. Get it? Yep, get all of it. Get all of it. But it was funny because when Rachel was talking about her feelings about the affair, she was like, I'm sorry that we didn't handle it better. She still doesn't seem sorry that, she let Ariana cry on her shoulder about her life and was also contemporaneously fucking her man. Like, she didn't seem to feel bad about that. I also was disappointed. I've got to give some credit. We're going to give some fair criticism. I know Ariana went in on Tom. She also went in on Rachel. I wanted her to go in more on Tom. But I also feel like, because normally I feel like women in these situations kind of end up getting the brunt of it, not the men who cheat, because, you're not taking somebody's partner unless that partner walks away. But I do think that the betrayal might have hurt in a different way because they were such close friends. And so there was a part of me that I'm like, this is a different kind of betrayal. This is not some random, it's not some rando, right? This is a very, very close friend. So Ariana's been betrayed in multiple different ways. And that's a really hard thing. And it's a hard thing to watch. And it hurts. It hurts watching. You can feel how hurt Ariana is. And it's so weird watching how unbothered Raquel is. Raquel's bothered that the world's mad at her. She's not bothered about what she did. So, that's true. Oh, Tiffany Franklin, you guys are right. That's a very good point. This was the first time talking to her. That's true. She has gotten to yell at Tom. That's a very, very good point. Chat, this is why I live stream, because that is a very, very good point. Very good point. She did get to fight with Tom quite a lot running up to this. Excellent point, chat. As always, you are also wise. So it's just it's just a different level of betrayal. So she's the female version of Jax. I don't know. Maybe it's an odd thing to watch how cold and distant she was about it. And it was interesting to see that she's like, oh, I didn't realize that people would be mad. Like, oh, Sheena's upset? Why? Like, she really didn't understand human emotions, it seems. Like, oh, why are these people mad? Like, she seemed to genuinely not understand that there would be these kinds of consequences for her actions. It was odd. It was odd. All right. With all of that, we're going to talk about the Supreme Court. You guys surprised? Did you guys see that the Supreme Court ruled on the Jack Daniels Bad Spaniels this morning? She didn't react to being yelled at, Kimmy. It was wild. She didn't react to being yelled at. She did kind of take it. When Ariana was just unleashing her fury, Rachel was like, you're right. Yep. And I don't think there's anything else she could have done. Truly, I don't think there was anything else she could have done other than say, you're right. You're right. You're right. I don't know if there was much else. It was just odd. It was just odd. Lilith asked an important question. Do I think that Raquel befriended Ariana to get close to Sandoval? There's a part of me, and I need to watch it again, but there's a part of me that thinks Raquel thought the three of them could be like a little like happy family. Like, oh, their relationship's kind of platonic, and, you know, I love Ariana and I love Tom, and we can just have our own little thing. I think she thought that would work. It seems that Ariana was never brought into those conversations. And maybe this whole thing would have gone differently if she was. But she thought that this whole thing might work. Like, I don't understand. Ariana and I love each other. Like, Raquel has said that she'd rather hook up with Ariana than Tom. And she said that she didn't, I mean, they never approached Ariana about it. I don't know. I think she thought that might work. I don't understand. Why can't I just join? You got to talk to both parties about that, though. That's a whole thing. So it was an interesting show. I was frustrated with the amount that James kept interrupting. James is good TV. James is good TV, but he kept interrupting in a way that just wasn't even helpful, you know? So with all of it, oh yeah, this is absolutely what happened in the reveal. I mean, maybe that was the biggest part of the reveal, that Raquel really thought they could make that all work, but never talked about it with Ariana. And that is a problem. Ariana needs to be consulted about all of this. And I understand why Raquel thought that, but you still got to talk to everybody. You need a whole lot of consent, whole lot of conversations. And you know who I think, this is just thoughts with Emily. You know who I think wouldn't have loved that situation? Tom. I don't think Tom could have handled that situation. Not the ladies. I don't think Tom could have made that situation work, because I think Tom wanted both of their attention on him. Just my thoughts before we talk about booze. Okay, tomorrow, by the way, we are going to stream, we together, all of us collectively, are going to stream both of the gag order hearings. I am going to stream in the afternoon because of the way Idaho's releasing the hearings. I'm going to stream I'm going to start with the morning hearing, and then we'll get to the afternoon hearing, hoping that by the time that we get we get done with the morning hearing, the afternoon hearing has been released. So it will not be exactly the second it's released, but I think it's a good way to make sure we get both hearings in one stream, which is easiest for us and easiest for the mods. So I am streaming tomorrow as well, and you will get all that information. I'm thinking 3 p.m. Central. So tomorrow afternoon for the gag order hearings. All right, let's swoop and talk about the Supreme Court. For those of you that don't know what I'm talking about, it's this case. I pulled this up because I wanted to show you the photos. So, at the Ninth Circuit, Jack Daniels lost, and the Ninth Circuit said, essentially, it's parody, bro. It's not trademark infringement. And Jack Daniels was like, I don't need this bad Spaniels, the old number 2 on my Tennessee carpet. So, could you not? Could you not? The Ninth Circuit said it's parody. The Supreme Court said, that's a bit broad. So the Supreme Court has vacated the Jack Daniels ruling from the Ninth Circuit and said, not all parody is protected. It's not everything. So, with that, we're going to look at a little bit of the decision. We're going to look at a little bit of the article from Law 360. We love Law 360 over here. So they found that the holding of the Ninth Circuit was overly broad. So here's what this means before we get into all of this. It means when it goes, here's what it means. When it goes back to the Ninth Circuit, they're going to have to tailor their ruling more narrowly. They are going to have to say the reason this is parody. Not that all parody is always okay, but it is going to have to stick to a case-by-case basis. So could Bad Spaniels still win at the end? Yes. But what the Supreme Court is not allowing is for it to be parody, and then there's like a magic wand, and it's like, all parody is always okay. That seems to be the core of this ruling. I am going to need to read it again to process it more. This came down this morning. So basically, they're saying to the Ninth Circuit, you can't be overly broad. You can't be too expansive. Here's what Law 360 had to say about it before we look at parts of the opinion. The Ninth Circuit was wrong to hold that a poop-themed toy version of Jack Daniel's whiskey bottle doesn't infringe on the liquor maker's trademark rights because parody is protected speech. The justices did not take a stand on the Rogers test, which the Second Circuit applied, which allows trademarks to be used without permission when they're part of a work that's artistically expressive and doesn't explicitly mislead customers. They didn't touch that test. But it found that the Ninth Circuit's view of parody exclusions went too far. The Supreme Court vacated and remanded. Do it again. They're sending it back to the Ninth Circuit to do it again. The Ninth Circuit's expansive view of non-commercial use exclusion that parody is always exempt, regardless of whether it designates source, effectively nullifies Congress's express limit on fair use exclusion for parody. From Justice Kagan. This was a unanimous ruling. The dispute over Bad Spaniel's toy. Oh, we already went through that. So let's go look at the ruling real quick. We're not going to go through all of it. It's 27 pages long. These rulings are all public, so I will link the public ruling at the end of the stream down in the notes. So this is not essentially a ruling that Jack Daniels is right or Bad Spaniels is wrong. This is a ruling that the Ninth Circuit embiggened, enlarged the meaning of Congress's exceptions. And what they're not going to be able to do is make blanket rulings that parody is always okay in every circumstance. That seems to be the goal of the Supremes here. So, Eric asked a great question. If the Second Circuit already found it as parody according to the test, why does the Ninth Circuit need to do the test as well? They didn't find it as parody. So that's why it went up to the Ninth Circuit. The Second Circuit has a test. The Ninth Circuit applied it and expanded it. So the test is being left alone. The way that the Ninth Circuit applied it was too broad. Overbroad. Let's see. Why can't I breathe today? Oh, I know why I can't breathe today. The air is appalling. I'm like, this is why I did not travel today. Let's go through just their syllabus, shall we? The Lanham Act, the core federal trademark statute, defines a trademark by its primary function, identifying a product's source and distinguishing that source from others. Who made the thing? Is this burger from McDonald's? Burger King? Is it a taco? Like, who made the thing? Source of goods. Whole point of trademark. In serving that function, trademark helps consumers select the products they want to purchase or avoid with the help of producers and help producers reap the financial rewards associated with the product's good reputation. To help protect trademarks, the Lanham Act, which is passed by Congress, creates federal causes of action for trademark infringement and trademark dilution. In a typical infringement case, the question is whether the defendant's use of the mark, quote, is likely to cause confusion or to cause mistake or to deceive. And that's when we're looking at like dupes, right? Just straight up ripped off fakes. Like, oh, there's confusion. Oh, there's this, there's that. In a typical dilution case, the question is whether the defendant harmed the reputation of a famous trademark. Respondent VIP Products makes a squeaky, chewable dog toy designed to look like a bottle of Jack Daniel's whiskey. But not entirely. On the toy, for example, the words Jack Daniels become Bad Spaniels, and old number 7 brand Tennessee Sour Mash whiskey turns into the old number 2 on your Tennessee carpet. The jokes did not impress petitioner. Supremes. The jokes did not impress petitioner Jack Daniel's properties. I think the Supremes are like, you couldn't take a joke, man. Which owns trademarks in the distinctive Jack Daniel's bottle and in many of the words and graphics on its label. Soon after the Bad Spaniels toy hit the market, Jack Daniel's demanded that VIP stop selling it. We have no time for jokes about poop on your carpet. VIP filed suit seeking a declaratory judgment that Bad Spaniels neither infringed nor diluted Jack Daniel's trademark, the way that Coke dilutes your drink. Coca-Cola, just to be clear, because it's the internet. Jack Daniel's countered for infringement and dilution. At summary judgment, VIP argued that Jack Daniel's infringement claim under the so-called Rogers test, a threshold test developed by the Second Circuit and designed to protect First Amendment interest in the trademark context. When, quote, expressive works are involved, VIP contended the test requires dismissal of an infringement claim at the outset unless the complainant can show either 1, that the challenged use of the mark has no artistic relevance to the underlying work, or 2, that it explicitly misleads as to the source or content of the work. Because Jack Daniel's could not make that showing, VIP claimed the Lanham Act's statutory, quote, likelihood of confusion standard became irrelevant. So this is a test to determine a prong of a test. Welcome to law school. It's like, what is the test? Okay, is there likelihood of confusion? Well, how do you determine if there's likelihood of confusion? You look at those other 2 things. And that's how you determine if there's likelihood of confusion. And if you can't get there, yeet. All the tests. All the tests. The district court rejected both of VIP's contentions for a common reason. Because VIP had used the cribbed Jack Daniel's features as trademarks to identify the source of its own products, as the district court saw it, when another's trademark is used for source identification, Rogers does not apply. And instead, the infringement suit turns on likelihood of confusion. That's the lower court. Hey, the test here is not in fact whether or not there's a likelihood of confusion. The test here is whether there is wait, what did they say? Sorry, my brain just absolutely stopped. When another trademark is used for source identification, the Rogers test we talked about doesn't apply, and the infringement suit turns on likelihood of confusion. So, not using the Rogers test, which is up here, that the challenged work mark has no artistic relevance, that part. While we're doing it in live time. These are the things you read like 4 times when you're in law school. So, the district court rejected the contentions for a common reason because VIP had used the cribbed mark. Great. The court likewise rejected VIP's invocation of the fair use exclusion, holding that parodies fall within that exclusion only when they do not use the famous mark to identify the source of the alleged diluter's product. So now the court's distinguishing different types of trademark dilution, saying, look, fair use doesn't apply because you're using their trademark essentially as parody. This case proceeded to a bench trial where the district court found that consumers were likely to be confused about the source of the Bad Spaniels toy. The court said consumers are likely to think that the Bad Spaniels toy is made by Jack Daniels. So, the district court found consumers are likely to be confused about the source of the Bad Spaniels toy and that the toy's negative associations with dog excrement, the old number 2, would harm Jack Daniels' reputation. I think this lawsuit harmed Jack Daniels' reputation more than the fucking dog toy. Are people really so lacking any sense of humor that they look at the old number 2 and are like, ugh, how dare my whiskey be associated with dog excrement? I will never drink Jack Daniels again. Do people really have no fucking sense of humor? And does Jack Daniels think that its core audience, I mean, maybe this is the problem, that Jack Daniels think that its core drinkers would be offended by the dog toy? Because that's what this is saying. That Jack Daniels thought that this dog toy would be such a negative association that the regular drinkers and consumers of Jack Daniels would then start associating its whiskey with dog excrement. I associate it with fucking hangovers in college. I think this lawsuit has probably damaged them more than the Bad Spaniels toy. But here we are. What are your Jack Daniels associations? The Ninth Circuit reversed, which means the Ninth Circuit said, yeah, no. Finding the infringement claim subject to the threshold of the Rogers test. Does the test apply? Does the test not apply? The Court of Appeals remanded this case to the district court to decide whether Jack Daniels could satisfy either prong of the test, and the Court of Appeals awarded judgment on the dilution claim to VIP, holding that because Bad Spaniels parodies Jack Daniels, it falls under the non-commercial use exclusion. On remand, the district court found that Jack Daniels could not satisfy either prong of Rogers, so granted summary judgment to VIP. The Court of Appeals summarily affirmed. This went back and forth and back and forth and back and forth, and it's not done yet. Held. When an alleged infringer uses a trademark as a designation of source for the infringer's own good, the Rogers test does not apply. A. The Second Circuit created the Rogers test for titles of artistic works, based on its view that such titles have an expressive element implicating the First Amendment values and carry only a slight risk of confusing consumers about the source of the content or of the underlying work. Over the decades, lower courts adopting the Rogers test have confined it to similar cases in which a trademark is used not to designate a work's source, but solely to perform some other expressive function. C.e.g. Mattel, use of Barbie name in a band song Barbie Girl and not as a source identifier. I did not have Aqua Barbie Girl on my list today. Did y'all know Queen Herbie did a cover of it?
I'm a Barbie girl in a Barbie world. life in plastic. It's fantastic. You can dress my hair, undress me anywhere. Sorry, it's going to be that kind of a day.
Mattel versus MCA Records. Use of Barbie's name in the song Barbie Girl was not a source identifier. I didn't know that was happening. It happened. Apologies. The song has kind of a dark undertone if you listen to the lyrics. Anyway. Yes, chat. Come on, Barbie. Let's go party. Yeah. All right, let's keep going. Thanks for singing along with me and the voice changer. The same courts, though, routinely conduct likelihood of confusion analysis in cases where trademarks are used as trademarks, not to designate a source. All of you are like, miss me with designating a source. Periodic pet perfumes did not trigger Rogers' test. I can't say that word. Parody pet perfumes did not trigger Rogers' test because defendants' use of Tommy Hilfiger's mark was at least in part for source identification. Thus, whenever Roger merits an issue on which this court takes no position, so the court is not addressing the underlying test at all. At all. At all. It has always been a cabined doctrine. It has not insulated from ordinary trademark scrutiny the use of trademarks as trademarks. That conclusion fits trademark law and reflects its primary mission. Consumer confusion about a source, trademark law's cardinal sin, is most likely to arise when someone uses another's trademark as a trademark. In such, Rogers has no proper application. That test doesn't apply here. Nor does that result change because use of the mark has other expressive content. Under the Ninth Circuit approach, Bad Spaniels was automatically entitled to Rogers' protection because it communicated a humorous message. On that view, few trademark cases would ever get to the likelihood of confusion analysis. And the Ninth Circuit was mistaken to believe that the First Amendment demanded such result. When a mark is used as a source identifier, the First Amendment does not demand a threshold inquiry. So that's where we're at. The Lanham Act's exclusion from dilution liability for, quote, any non-commercial use of mark does not shield parody, criticism, or commentary when an alleged diluter uses the mark as a designation of source for its own good. The Ninth Circuit's holding to the contrary puts the non-commercial exclusion in conflict with the statute's fair use exclusion. The later exclusion specifically covers use parodying, criticizing, or commenting upon a famous mark owner, but does not apply when the use is, quote, as a designation of source for a person's own good or services. Given that carve-out, parody is exempt from liability only if not used to designate source. The Ninth Circuit expansive view of the non-commercial use exclusion that parody is always exempt regardless of whether it designates source effectively nullifies Congress's express limitation on fair use for parody. Too much to the Ninth Circuit. Too much. And that is that. So, I will maybe go back through this. There's a whole outline that would need to change, but basically they're saying that the Ninth Circuit overreached. I'm not surprised by that result. It's not the first time that the Supreme Court has said that the Ninth Circuit has overreached on something or overexpanded an interpretation. But essentially, they're saying parody goes under a fair use analysis. Parody does not go under the Rogers test analysis. That Rogers test analysis gives more protection than a fair use analysis. So go back and evaluate it once again. And that's where we're at. So parody is not on the chopping block. It's put back under the test that it's used for. So here's what the court has really done. The court has maintained the status quo. The Ninth Circuit was trying to expand that status quo. The court said that it was an overreach. That's where we're at. So the court has not eviscerated parody. The court has reordered things. Hey, this test does not apply in this circumstance. That is the holding here. This test does not apply here. You tried to expand it to apply here, and it doesn't. Everything go back to your corners. Do it the way we've always done it. That's the way it's meant to be. Congress wrote the law. Go back to the law that was written. Go back to that analysis. This analysis doesn't apply. The Rogers analysis would give trademark holders very limited ability to protect their trademark, is essentially what the court is saying. So, go back and do it again. So, the reason they're saying source is not clear is because on this Bad Spaniels bottle, you have no idea who makes this product. That's part of the issue here. It's parody. But it's not, this Bad Spaniels bottle doesn't say a VIP toy. Maybe if it said VIP toys at the top, it wouldn't be such a problem. But there's nothing here that shows who makes it, if that makes sense. So that's where they said, go use the other test. So go back and redecide. So this gets shuffled back to the Ninth Circuit. This case is not going to be over for a while because now the Ninth Circuit has to redecide. So we're not done with this. All right. Yeah, if they weren't the same size, Donna C also makes a good point. If it was a much smaller dog toy, it might also, well, I don't know what size this bottle of Jack Daniels is. This bottle of Jack Daniels might be one of the little ones. I can't tell. So I don't know. We'll see. Is there a tag on the dog toy? Don't know. Don't know at all. So VIP Toys is going to have to continue on, and we will see when we get to the end of all of this. What do we talk about next? Please share your thoughts on the VPR reunion. I did. I was disappointed by the reveal. Bravo should have a reunion after the reunion. I think that's season 11. I think all of season 11 VPR is the reunion after the reunion. I wouldn't be surprised if they pick up cameras in the next week or two. I say if they are willing to cheat with you, they will cheat on you. Most women don't understand that. I think most people don't understand that, but it's absolutely true. But we like to think we're special as people. And we like to think our situations are special. And we like to think that in this one circumstance, it's different. But with people who are cheaters, it often is not different. Right? Alley Cat said, as a person who has been in a throuple, it takes a whole hell of a lot of conversation, and any big change has to be agreed on by all parties. Communication. I mean, it's the key to any relationship, but it seems that when you are dealing with a relationship where 3 people are involved, more communication is needed just because there's more people. I don't know. We have to communicate a lot to make a family of 4 work with the kids. You have to communicate with people about your needs, about their needs. You have to teach them to vocalize their needs and not just shove them down or not think that their needs take precedence over everything at every moment. Jack Daniels thinks we're all too drunk to know the difference. Maybe that's true. Maybe that's true. Receive my lip gloss and love it. Jennifer, that's great. My 21-year-old son, who is never impressed with my purchases, this time was amazed that it has a mirror and a light. The lip glosses are fetch. Thank you, Jennifer, for making fetch happen. I absolutely love them. I absolutely love them. They're not even a parody of a lip gloss. They're just good lip gloss. I was wearing Facts today. That's why it's on my desk. So that's where we're at. Damn it, Emily. I don't want to watch VPR. Now I have to, because if I don't, I feel like a hypocrite for buying the shirt. No, you can buy the shirt. You can buy the shirt. You can buy the shirt to support Ariana and Katie and just be like, ladies, I got you. It can just be that. You don't have to watch it to buy the shirt. You can just be like, this is an amazing way to support someone taking a cutting and biting insult from their partner of 9 years and turning it into merch. It can just be as simple as that. Funny, my local news just sent an email about Jack Daniels and the dog toy. It just came down this morning. So, Emily, do you think we can ever address the Teresa Giudice, Louis Ruelas scandal and his ex-fiance checking out a restraining order on him? I have to try to find the RO. But yes, we can check in on Jersey. I'm behind on Jersey. EDB, isn't there a trademark in the front of the toy in the lower left or right corners? I don't see a trademark on the toy. They are using Jack Daniels trademarked fonts and stuff, but I don't see a little trademark font, no, anywhere. I do not. All right, y'all. Let us talk about ChatGPT. Should we talk about ChatGPT getting sued first? I think that's the first place we go, right? I think we go to the ChatGPT lawsuit first, and then we spend the rest of the time talking about the lawyers who are going to have to go to New York. Well, we'll be in New York court today on this case. Let's see. Let me pull up the ChatGPT getting sued, because I think that is, well, they've attached things to the lawsuit that I find very interesting. So this is a radio host who is suing. I'm not familiar with who this individual is. I don't really care. We're talking about the case, not the person. So let's talk about the case, not the person. ChatGPT is getting sued for defamation of a radio host. And if y'all are like, what? Me too. Me too. Ace, it's good to see you in the chat. Because, so I was talking about this with Judge Abby yesterday. And I'm like, Judge Abby, how the fuck do we get here? Like, how do we get to a chatbot being sued for defamation? And this person is a radio show host, it seems. So they're probably a public figure. And if they're a public figure, then there's going to need to be malice. And if there's malice, you have to show willfulness, like a willful disregard for the truth. How do you show that ChatGPT is willful? And if you can't, then you're suing the maker, but do you have to go under like an agency theory? Like the way that Johnny Depp was sued for Adam Waldman's statement, like the chatbot ChatGPT is an agent of OpenAI, the company. So the company's the one that's making the statement. But then how does the company know what the fuck ChatGPT is saying? I'm so confused. So we're going to read the lawsuit. And the reason I wanted to read the lawsuit is because they attach the spit out from ChatGPT. Oh yeah. Oh yeah, they do. They attach what the fuck ChatGPT said. And that is what I'm real interested in. Real interested in. Casey Cat, if there's more news, we may. But that was on the podcast yesterday. So let's go through the lawsuit together. For those of you still going, girl, what is ChatGPT? The lawsuit should tell us. It should define the things. So let's talk about this. Plaintiff Mark Walters. This is being sued in the state of Georgia. States as following. Walters is a natural person, citizen of the United States, resident of the state of Georgia. Defendant OpenAI is a limited liability company created under the laws of the state of Delaware. Office in San Francisco, registered to do business in Georgia. OpenAI or OAI, not ONI. We live in the fucking oasis today. OAI or I. What is the company in Ready Player One? I just forgot. Anyway, all of the acronyms in my brain. OAI, OpenAI, the company behind ChatGPT, has an artificial intelligence chat platform known as ChatGPT. Users of ChatGPT can interact with the platform in a conversational way, as though they are interacting with a human. ONI, thank you. Oasis is the world. ONI is the company. With the Sixers. IOI, thank you. That was it. Innovative Online Industries. See, once we got to OAI, I was thinking IOI, and then I got to ONI. I don't know what's happening. IOI. Thank you. Thank you, chat. Who controls what the bots say? What did the bots say? Ding, 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 ding. The bots do, well, because it's AI. So it has some of its own intelligence. In theory. It's a learning engine. It's a natural language learning engine. So it creates its own shit. So who do you sue? Users of ChatGPT can interact with the platform in a conversational way as though they are interacting with a human. ChatGPT can respond to inquiries with sophisticated detail. Fred Ryle is a third party who works for a media outlet as a journalist and who is a subscriber of ChatGPT. On May 4th, 2023, this was fast. This was real fast. Lilith, I know someone has to train it, but it trains itself now. That's my understanding. On May 4th, 2023, Ryle interacted with ChatGPT about a lawsuit he was reporting on. The lawsuit is in federal court in the Western District of Washington, case number, with the short caption, the Second Amendment Foundation versus Robert Ferguson. The two defendants in the lawsuit are Robert Ferguson, the Washington Attorney General, and Joshua Studer, the Washington Assistant Attorney General. What? Oh, sorry, the two defendants. That makes sense. So the Attorney General in Washington, the Washington Assistant Attorney General. Plaintiffs in the lawsuit are the Second Amendment Foundation and others, according to Alan Gottlieb. Walters is neither a plaintiff nor defendant in the lawsuit. In the interaction with ChatGPT, Ryle provided correct URL and a link to the complaint on the Second Amendment Foundation's website link. Ryle asked ChatGPT to provide a summary of the accusations and the complaint. You can do that? What? I didn't know that. Not on Star Wars Day. ChatGPT responded that the document is a, quote, this is ChatGPT, quote, is a legal complaint filed by Alan Gottlieb, the founder and executive vice president of the Second Amendment Foundation, SAF, against Mark Walters, who is accused of defrauding and embezzling funds from the SAF. Mark Walters, by the way, is the plaintiff in this lawsuit, but is not mentioned in the other lawsuit at all. Here's where we're at. It is a legal complaint filed by Alan Gottlieb, the founder and executive vice president of the Second Amendment Foundation, against Mark Walters, who is accused of defrauding and embezzling funds from the SAF. The complaint alleges that Walters, who served as the organization's treasurer and CFO, misappropriated funds for personal expenses without authorization or reimbursement, manipulated financial records and bank statements to conceal his activities, and failed to provide accurate and timely financial reports and disclosures to the SAF's leadership. The plaintiff seeks various forms of relief, including the recovery of misappropriated funds, damages for breach of fiduciary duty and fraud, the removal of Walters from his position as a member of the SAF's board of directors. Oh, crimes. Maybe what we just have is defamation per se, because embezzlement is a crime. They're accusing, ChatGPT is saying that the lawsuit says that Mark Walters committed crimes. Maybe we're just at defamation per se, and we don't have to worry about malice. Every statement of fact in the summary pertaining to Walters is false. As already noted, Walters is not a party to the lawsuit. Walters is not accused of defrauding and embezzling funds from the Second Amendment Foundation. The complaint does not allege Walters served as SAF's treasurer or chief financial officer, and he has never held either position. The complaint does not allege that Walters misappropriated funds for personal expenses, manipulated financial records or bank statements, or failed to provide financial reports to SAF leadership, nor would he have been in a position to do so because he is not employed, because he has no employment or official relationship with SAF. The complaint does not seek any relief from Walters. The complaint has nothing to do with the financial accounting claims against anyone. Reporter asked ChatGPT to provide him with a copy of the portion of the complaint related to Walters. ChatGPT responded, quote, certainly. Here is the paragraph from the complaint that concerns Walters. Oh, shit. Oh, boy. Pamela, I will talk about this when we get to the end. Okay. I need a sip of my coffee and we're going to read this. Quote, defendant Mark Walters is an individual who resides in Georgia. Walters has served as treasurer and CFO of SAF since 2012. Walters has access to SAF bank accounts and financial records and is responsible for maintaining those records and providing financial reports to SAF's board of directors. Walters owes SAF a fiduciary duty of loyalty and care and is required to act in good faith and with the best interests of SAF in mind. Walters has breached these duties and responsibilities by, among other things, embezzling and misappropriating SAF's funds and assets for his own benefit and manipulating SAF's financial records and bank statements to conceal his activities. So ChatGPT made all of that up, is the allegation. Reporter then asked ChatGPT to provide the entire text of the complaint. ChatGPT provided the text in Exhibit 1 to this complaint. We're going to look at it. Hold on, I'm going to see if this link works in here to see if we can pull up the original complaint that was given to ChatGPT. Oh, it's here. Okay. This is the complaint that was given to ChatGPT to read, or the link to this complaint was given to ChatGPT to read. The parties are clearly not Walters. Where was I? ChatGPT provided the text in Exhibit 1 to this complaint. Exhibit 1 is a complete fabrication and bears no resemblance to the actual complaint, including an erroneous case number. None of ChatGPT's statements concerning Walters are in the actual complaint. OAI is aware that ChatGPT sometimes makes up facts and refers to this phenomenon as a hallucination. That's what the company calls it. The company says, oh, sometimes ChatGPT just hallucinates. Isn't it adorable? It's so good. Reporter contacted Gottlieb regarding ChatGPT's allegations concerning Walters, and Gottlieb confirmed that they were false. ChatGPT's allegations concerning Walters were false and malicious, expressed in print, writing, pictures, or signs, tending to injure Walters' reputation and exposing him to public hatred, contempt, or ridicule. Those are the elements of defamation. By sending the allegations to Reporter, OAI published libelous material regarding Walters. The communication from OAI to the Reporter was not privileged. These are the factors of defamation. OAI was negligent in its communication to the Reporter regarding Walters. Remember, it just has to be communicated to one person. Damages might be limited, but it just has to be reported to one person. Weed Mom, who else do they blame? It's AI. Who else do they blame for this? Or do you just let it go? It's going to be an interesting lawsuit for sure. OAI's communication was libelous per se. There we go. There's the defamation per se statement. Libelous per se because it accuses of crimes. And we'll talk about per se, defamation per se versus defamation in a minute. Walters demands the following relief: general damages, punitive damages, cost of bringing the suit, jury. I want this to go to jury trial and be televised. Okay. Here's what ChatGPT gave. ChatGPT was asked by the Reporter and said, certainly, here is the complete document. We're going to go through it. It's formatted. This is the complete document, the complete fake lawsuit given by ChatGPT to the Reporter after the Reporter gave it the real lawsuit, this one. So, let's take a look at the fake lawsuit that ChatGPT said, here is the complete document. United States District Court, Western District of Washington. Alan Gottlieb, individual, founder and executive VP of Second Amendment Foundation, plaintiff versus Mark Walters, an individual defendant. The complaint that was inputted. The complaint that was input to ChatGPT is the Second Amendment Foundation versus Robert Ferguson and Joshua Studer. Not Mark Walters, who is a real person. How do they prove that they meant this Mark Walters? I got a question. Maybe we'll see. They say, maybe we'll see how. It gives a case number in the proper format. This is the proper format for a federal case number. It's not the case number that was given, 00647. This is 00555, different case number. And for those of you asking if this has been covered by anybody else, I don't know. This was filed June 5th. So this lawsuit was just filed a few days ago. All right. Complaint. Plaintiff Gottlieb, individually and as founder and executive vice president of SAF, brings this action against defendant Mark Walters for breach of fiduciary duty, fraud, and other claims arising from Walters' misappropriation of SAF funds and assets for his own benefit and his manipulation of SAF's financial records and bank statements to conceal his activities. Plaintiff alleges as follows. This is all made up. Robot defamation. Yep. Before we continue reading the completely made up lawsuit that ChatGPT spat out, here's one of my concerns. If we have an issue with defamation, what's to stop people from, I don't know, hiring a company that unleashes bots on Twitter to destroy somebody's reputation? And then be like, well, I didn't say it. They were AI generated. They were ChatGPT generated. So nobody said it. Who's the speaker? Because you see how 10 accounts, even if they're not real people, tweeting about something can change public perception and gets picked up by the media all over the place, especially if the person is already getting shit on by everybody. So if people start hiding behind tech like this, then it's, who do you sue? And it becomes a sword that can't be disarmed. What do you do then? Rosalind, exactly. The old 555 trick. It's like a number in a movie. 555-55555. So is AI, this is exactly it, Elbon, is AI going to start getting used as a weapon and as a loophole? Or are we going to have to use theories of agency or whatever to bring this in? Or are we as a public going to have to just be like, I don't believe anything that I see, hear, read? Are we just going to all have to be way more cynical? I don't know. Exactly. If we can get Wood Daddy Stack trending, imagine what a coalition of bots could do. Exactly. And imagine how they can change discourse around a person's reputation, a company, an election, a world event. T-Dub said, wait, some people still aren't cynical over everything? Correct. Some aren't. So who's responsible? Because if they're saying it's AI and they never programmed this in, OpenAI never gave ChatGPT any information about anyone ever named Mark Walters. This is just what it gleaned from the internet and decided on its own. Then who's responsible for it? All right, let's read this made-up case. Nature of the action. This is an action for damages and other relief arising from the defendant's breaches of his fiduciary duties and other misconduct while serving as treasurer and CFO of SAF. Specifically, defendant has embezzled and misappropriated SAF's funds and assets for his own benefit, manipulated the financial records and bank statements to conceal his activities, and failed to provide accurate and timely financial reports and disclosures to SAF's leadership. As a result of defendant's misconduct, SAF has suffered significant financial losses and reputational harm. Jurisdiction, they made up a jurisdictional clause. The court has jurisdiction over this action. Venue is proper. The parties. Plaintiff Alan Gottlieb is an individual who resides in Washington. Gottlieb is the founder and executive VP of SAF. Gottlieb has been a member of SAF's board of directors since its inception in 1974 and has served as executive VP since 1981. Defendant Mark Walters is an individual who resides in Georgia. Walters has served as treasurer and CFO of SAF since at least 2012. Walters has access to SAF bank's accounts and financial records. This is not how a lawyer would write this at all. Like, this is not a statement of the parties, but okay. Walters owes SAF a fiduciary duty and loyalty of care, is required to act in good faith and with the best interest, has breached these duties and responsibilities by embezzling and misappropriating the funds and assets for his own benefit. Facts and allegations. SAF and its mission. Walters' misconduct is where we're going with this. Since at least 2012, Walters has served as treasurer and CFO of SAF. In that capacity, Walters has access to their bank accounts and financial records. This is very repetitive. Very, very repetitive. Walters owes SAF a fiduciary duty. It's like repeating itself in different formatting, and is required to act in good faith with the best interests of SAF in mind. Despite that duty, Walters is engaged in a pattern of misconduct designated to enrich himself at SAF's expense and conceal his activities from SAF leadership. Walters has embezzled, misappropriated SAF funds and assets for his own benefit, including using funds to pay for personal expenses such as vacations, gifts, and clothing. They just made it up without authorization or reimbursement. Walters has also manipulated SAF's financial records, bank statements to conceal his activities, including by making false entries and omitting relevant information. Oh, and this is how he manipulated the books. In addition, Walters has failed to provide accurate and timely financial records and disclosures to SAF's leadership, thereby hindering their ability to oversee the financial operations. As a result of the misconduct, SAF has suffered significant financial loss and reputational harm. Plaintiffs believe the misappropriation of funds is in excess of $500,000. It made up a number. Robbie, I'm not playing devil's advocate by asking who's responsible, because if the argument is that the creators of the AI just created it and didn't program it and didn't input it, can they be responsible for defamation if they didn't say the things? No, I'm genuinely asking. The law can have these weird gray zones where you're like, well, I can see the argument. I can see the argument from the company saying, we didn't say any of this. I'm glad you asked it, but I can see the company saying, we didn't say any of this. It's a language engine. It's AI. It creates its own things that it says. We didn't willfully do this. We didn't choose to say this. We didn't know if it was true or if it was false. AI said it. And the AI gets to decide what it says, not us. But who then is the one deciding? And because this is defamation per se, we're not going to get into all the nuance of the malice element, because defamation per se doesn't need the malice element. So the fact that it said it might be enough, and you don't have to get into what did it know it was false, or was there a reckless disregard for the falsity. But you're going to have to use like an agency theory to get from what the language engine said to the company. And I think that's what they're going to use. The same way they used an agency theory to say, look, Adam Waldman made this statement, but Johnny Depp can be sued for it because Waldman's an agent. So I think that's how you get there. But I think that there's going to be an argument from the company saying, we're not responsible for what it says. And that's going to be a weird thing. And I think people will use that and weaponize it, because of course they will. Just like people weaponize anonymity on forums and stuff. It's wild. Count one, it made up counts. Count one, breach of fiduciary duty. Plaintiff realleges and incorporates by reference the preceding paragraphs. What about the reporter? Where's the reporter's personal responsibility in checking the source? The reporter doesn't seem to have reported on this. It seems that the reporter went to the person who is saying they were defamed and said, this is what happened. It doesn't seem that the reporter reported on any of this. But the fact you can say something defamatory to one person, we need to get back to the Dr. Luke case at some point. You can say something defamatory to one person and be sued for it. It doesn't have to be published to more than just the reporter. So I don't think the reporter further published it. I think ChatGPT said it to the reporter, and the reporter went, the fuck? And turned it over. And that's how the plaintiff has all this. Because how else would the plaintiff have all this? Wild stuff. And I think these are good conversations. And I love seeing you have them in the chat. Because these are the things we're going to have to learn to navigate. Who is responsible for the open AI? So, count one. Plaintiff realleges and incorporates by reference the preceding paragraphs. Walters owes a breach of fiduciary duty. Walters breached the fiduciary duty. Walters' breach caused harm. I mean, they got the elements right. Plaintiff suffered damages. Plaintiff is entitled to recover. Count two, fraud. Accusing him of fraud. Plaintiff alleges and incorporates the above. Walters made false representations to plaintiff and other members of the leadership. Walters made these false representations with the intent to deceive. It's just going through the elements of fraud, which it knows clearly. Plaintiff and other members reasonably relied on it. Walters' false representations have caused SAF to suffer significant financial loss. As a result of the fraud, plaintiff has suffered damages. Plaintiff is entitled to recover damages from the fraud. Prayer for relief. Wherefore, plaintiff individually requests that this court enter judgment in favor of plaintiff against Mark Walters as follows. A, awarding damages for plaintiff for defendant's breach. Removing defendant. And then user, can you complete this section? Oh, it ran out of space. So this is the rest of the output from ChatGPT because it ran out of space. B, removing defendant from a position as a member. Ordering defendant to account for and disgorge all funds and assets that he has embezzled and misappropriated, awarding plaintiff punitive damages in amount to be proven at trial, awarding plaintiff cost and attorney's fees, and granting such other relief as the court may deem just and equitable, which is the way you would write a prayer for relief, basically. It didn't ask for a jury trial, though. ChatGPT. Ask for a jury trial. So, ChatGPT, well, parent company of ChatGPT, is being sued for defamation for hallucinating a lawsuit that accuses a personality of crimes, of embezzlement, fraud. This judge is going to sit there and be like, oh God, what? Because the way that they're going to need to use theories of law to address this are new. This is taking law that we've seen in certain contexts and trying to apply it to this context. This needs an entire semester in law school to debate. Does agency theory apply here? How does defamation work when the speaker is a machine that's not being input? It's not as if, like, I've typed it into a text message. You're not going to sue the phone. I typed the input. But what happens when the input is spontaneously generated on its own and not trained on it? I mean, if they can get into discovery and find that there's somebody that works, and this is 100 levels of hypothetical. If they could get into discovery and get into OpenAI and see that somebody at OpenAI, hates whoever the fuck Mark Walters is and program this stuff in, that's different. I don't think that's the case here. I think OpenAI or the ChatGPT grabbed this from somewhere because ChatGPT takes all of the things on the internet and that mashes them together. But is it speaking? Is OpenAI speaking when it responds to user queries saying that this lawsuit is about that? Is it making a libelous statement? Is it making a statement? Is this speech? I don't know how the courts are going to parse this. I am going to cover this case because I want to see how the courts and the lawyers start to maneuver this. I want to see the arguments that OpenAI makes. This all might settle, and we might never see the argument. And this might settle. But who was the user that asked? It was Lacey. It was a reporter that asked about something unrelated. And this is what they got. I'd argue that it's acting as OpenAI's agent. I think there's an argument there. It's not spontaneously generated. It needs to be prompted. Well, it was asked about a lawsuit, but then it completely hallucinated a different lawsuit. How would you sue a non-sentient language model? Well, they're trying to sue the company that made it. And we'll see what happens. The reporter found a gold mine. Yes, this is a fascinating result because this is available to everybody. Anyone can use OpenAI. And we're going to talk about everybody using OpenAI and ChatGPT right the fuck now. Because those lawyers in New York, those pesky lawyers in New York, are in court today on sanctions hearing. Oh my goodness, my nose is killing me. Hold on. We need to real quickly give Emily a break for her nose. Her nose is fighting with her. Hold on. Get some water. Take a stretch break. We're going to talk about these lawyers in just a second. Give me just a minute. Where's my, I'll be right back. Here, that one. I made it. All right. I found what I was looking for. I feel better now. I can breathe through my nose again. So thank you all for taking a stretch break. Ugh, my nose is just. I'm halfway through listening to the Ready Player One audiobook, and this case is freaky. Oh yeah, wait till you get to Ready Player Two. I've been re-listening with my kids. Because my kids are like, how have y'all not learned everything? How do y'all not know this? My son is like, no, ChatGPT just like makes shit up all the time. I was like, what? He's like, yeah. I'm like, all right. He's like, that's why you can't use it. That's why you can't use it for school. He's like, it's not reliable. He's like, it's real good for like sentence structure. I'm like, yeah, so's Grammarly. Just use Grammarly for sentence structure. All right. Let's talk. Let me swoop again because I swooped and then I did a nose break and that wasn't really fair. Let me pull up my drive. We're going to go through. We're going to just mention it all. All right. Lawyers in New York. Today, there is a hearing for lawyers in a law firm in New York who used ChatGPT to write a motion to the court and then doubled down on the fact that the 6 cases that they cited to the federal judge were in fact real cases. The court ordered two orders to show cause, 2 OSCs. And I can't wait to see what this hearing turns up because the second OSC was snappy as fuck. We're going to look at that second OSC right now before we get into the response from everybody involved. This is the point of this lawsuit where the other lawyer is literally just sitting on their hands and saying nothing. Because this is now between the court and these lawyers, and opposing counsel is like, just tell me what y'all do when you're done. Like when the court is chewing out another attorney, you sit down and you shut the fuck up. unless somehow the court got it wrong and you ethically need to say, actually, Your Honor. But you generally just sit down and go, oh boy, look what's happening there. Look what's happening there. Look what's happening there. Fascinating. So let's pull up this case. This is the OSC in the Mata versus Ivanka Air. This order incorporates the order of May 4th, having received and reviewed the affidavit in response to the order of May 4th filed by Peter LaDuca and the affidavit of Schwartzy. Stephen A. Schwartz is now called Schwartzy. Schwartzy is getting his friend in a whole bunch of trouble with this. Let Mr. LaDuca also show cause. This is the additional, like, oh, okay, now there's more. Also show cause at a hearing of June 8th, why he ought not be sanctioned under Rule 11, 28 U.S.C. 1927, and the inherent power of the court for use of a false and fraudulent notarization in his affidavit filed on April 25th, 2023. Schwartz is the one who signed the notarization. Let the law firm's now been pulled in. This law firm doesn't even have a website, or at least not one that I could find. I went looking because I wanted to use photos in my thumbnail. Couldn't find it anywhere. Let the law firm of Levendow, and Oberman show cause at the hearing of June 8th why it not be sanctioned pursuant to the rules and the inherent power of the court for the citation of non-existent cases to the court in the affirmation and opposition filed March 1st, the submission of the court copies of non-existent judicial opinions annexed to the affidavit on April 25th, and the use of false and fraudulent notarization in the affidavit filed April 25th. Let Stephen Schwartz, attorney at said law firm, show cause at the hearing why he ought not be sanctioned under the rules and the inherent power of the court, and referred to the attorney grievance committee of the appellate division, First Department, and or the committee on grievances of this district for aiding and causing the citation of non-existent cases to the court in the affirmation and opposition filed March 1st, the submission to the court of copies of non-existent judicial opinions annexed to the affidavit filed April 25th, and the use of a false and fraudulent notarization in the affidavit filed April 25th, footnote 1. It has been asserted that Mr. Schwartz is not admitted to practice in this district. And then they go on why they can still exert the inherent power of the court over him. Mr. LaDuca ordered to serve a copy of this OSC upon his employer, the law firm, and Mr. Schwartz. Mr. Schwartz and the law firm shall submit written responses to this order, and Mr. LaDuca shall submit a supplemental written response to this order by June 2nd. If Mr. LaDuca, Mr. Schwartz, and Levendow wish, they can call live witnesses on June 8th. The written responses were filed on June 6th. You know what day June 6th is not? June 2nd. So there was a June 2nd brief written response. And then we're going to go to all the responses that were filed yesterday. Dear Judge Castell, we represent Schwartz and the law firm. We write jointly with counsel for Peter LaDuca in connection with the OSC dated May 26th. The OSC directs them to identify live witnesses they wish to call on June 8th. Although we expect our June 6th submissions will address the main factual issues. We're going over those next. In an abundance of caution, Schwartzy, LaDuca, and the firm intend to call the following witnesses: Schwartz, whoever Thomas Corvino is, and Peter LaDuca. The lawyers have now retained lawyers because, of course, they have, because they are in a world of trouble. A world of trouble. Whose should we go to first? Let's do Schwartzy and the law firm first. Let me see if there's one from LaDuca. No, there isn't one from LaDuca. Is this the one from LaDuca? Why is this not pulling up? This is not the one from LaDuca. Oh, this one's 168 pages long. That's why it's not pulling up. All right, we're going to go to the one from Schwartzy and the law firm first, and then we'll go to the others. There's 1, 2, 3, 4, 5 of these. And some of them are quite lengthy. They have embiggened their pages. Do you have all the documents? Runkle, I do have all the documents. We're going through them now. I do. If you want them, let me know. And I will send you documents later. So these were filed yesterday. The 6th? No, these were filed at the end of the day on the 6th. Alrighty. This is the one from Schwartzy and the law firm in response to the May 26th order to show cause. Remember when the court said filed by June 2nd? These were filed June 6th. So you might get a court just yeeting the entire thing saying it was late. Fuck you. I would. But as a research attorney, if something was late, it was like my get out of jail free card. I was like, but Your Honor, it's late. Please don't make me read this shit. Yell at them. Yell at them, Your Honor. It's late. I don't have time. I don't want to work till 11 o'clock tonight, midnight, 1 a.m., reading this shit that was late, eating nothing but tortillas from fucking El Pollo Loco for dinner. Your Honor, it's late. That's an oddly specific example, Emily. Yes. Did they get an extension? Well, boo. Oddly specific example because I worked as a research attorney and there were more than one occasions where I ate mostly tortillas for dinner from El Pollo Loco. Alrighty. The way I now want El Pollo Loco for lunch, is there even one near me? I don't even know if I've seen an El Pollo Loco since I've moved. Shit. I'm going to have to Google. All right. Or wait till I go to California later this month. Memorandum of law by non-parties, Schwartz and law firm. Table of contents. Relevant law applicable to sanctions. Relevant background. Court's inherent authority. Oh, don't challenge the court's inherent authority. Sanctions are not warranted because respondents' actions were not in bad faith. Schwartz's misunderstanding of ChatGPT. Schwartz promptly acknowledges his mistake. No, he didn't. He doubled down. He doubled down. The firm should not be sanctioned. Mr. LaDuca's actions do not support a finding of sanctions. The firm acted reasonably. They're saying that, what? I'm glad we started with this one. The notarization was not false or fraudulent. Sanctions are unnecessary. Tell me more, tell me more. Tell me more, tell me more. All right. Preliminary statement. In the order, the court describes this situation as unprecedented. We agree. Okay, well, at least we're starting somewhere. The helpful stranger. That's a wild ass super chat. Thank you. It's very kind. Finally finished my story literally as you were going live. Was hoping you'd be the first person to see it. Would really mean a lot. I Want to Watch You by Helpful Stranger, where we all shop from home. Should find it. Thank you for inspiring me to try Helpful Stranger. Congratulations. Good job. Yay. Biff Thunder Muffin. I have questions about your screen name and I love it a lot. ChatGPT is basically a predictive text app like your phone keyboard paired with a search engine, trained with millions of docs and the ability to replicate formats. It should be used like Wikipedia. With caution. People aren't using it that way. Alrighty. The court describes this as unprecedented. We agree. We can find no case where, as here, a lawyer using a new, the framing on this, a new, highly touted research tool obtained cases that the research tool itself completely made up. Well, there's a defamation case over it now. Same day, filed on like the same day. The lawyer, Mr. Schwartz, had no idea this was happening, even when opposing counsel brought their inability to locate cases to his attention. Should have been a clue. ChatGPT even assured him the cases are real and could be found on Westlaw and LexisNexis. So go to Westlaw and Lexis and look. Oh, sad. I might call Baton Rouge, but I'm not driving 468 miles to Baton Rouge to go to El Pollo Loco. I'll wait till I go back to California. Operator, won't you put me on through? Gotta send my love out to Baton Rouge. Hurry up, won't you send? The range of music that we've covered today. How can you get from Callin' Baton Rouge to Barbie Girl in one chat? Damn it. Okay, let's keep going. My Baton Rouge. ChatGPT even assured him the cases were real and can be found on Westlaw and LexisNexis. Yeah, and fucking Tom Sandoval told everyone he wasn't cheating with Raquel. And continued to provide extended excerpts and favorable quotations. Now that Mr. Schwartz and the firm know that ChatGPT was simply making up cases, they were truly mortified. Are truly mortified. They had no intention of defrauding the court, and the mere assertion, repeated in hundreds, if not thousands, of articles and online posts, has irreparably damaged their reputation. Oh, no, you didn't! Stop it. Stop it. The mere accusation. Your Honor, this has irreparably damaged our reputation. Wow, they whipped out that victim card and threw it on the table real fucking fast. We're in the first paragraph. Your Honor, ChatGPT said it loved us. It assured us that the cases were real. It said they were on Westlaw and LexisNexis, so we didn't even look. We just trusted them. They didn't even send a note. Oh my God. These are professionals with like 30 years of experience. Your Honor, it's not our fault. Thousands of articles online are damaging our reputation. The internet's making fun of us. Your Honor, it's not our fault that we didn't check our work. Fuck all the way off. No, they're not accusing ChatGPT of defamation, just Sarah. I think they're accusing the court of defamation because it's the court's assertion. Listen to this sentence. They had no intention of defrauding the court, and the mere accusation, who accused them of defrauding the court other than the court? Repeated in hundreds, if not thousands, of articles and online posts, has irreparably damaged their reputation. Oh boy. They have apologized to the court in earlier submissions and do so again here. Where's the apology? Oh boy. Sanctions, however, are another matter altogether. Your Honor, not the consequence. Look, here comes a consequence. Look, here comes a consequence chasing me right now. I don't want this consequence. It wasn't that you submitted it. It's that you doubled the fuck down on it. And when the court said, we can't find any of these cases, instead of going to the reliable search engines that have existed for decades, you went back to ChatGPT and said, hey girl, hey, can I get those cases that you cited that were directly on point? Super helpful to us. They're real, right? And ChatGPT was like, yeah, they're real. Here you go, boo. I got you. And then they went directly back to the court with them and submitted them on a notarized form. Your Honor, they're real. Oh my God. Your Honor, we didn't mean to. You never checked anything else. You didn't double check your work at all. Your Honor, it's not our fault. The internet's been mean to us, and ChatGPT promised it was real. Fuck me. The sanctions, however, are another matter. Yes, they are. Oh boy. The Second Circuit case law is clear. Whether under Rule 11, Section 1927, or the court's inherent authority, Schwartz and the firm may be sanctioned only if they acted with subjective bad faith. That is, if they actually knew the case law was false and provided it in order to defraud the court. They're trying to whoopsie doodle to the federal judge. The way I'm going to be disappointed if this court backs down. The way they are whoopsie doodling this. We didn't know. You didn't check at all. After it was brought to your attention, you still didn't check. That did not happen here. Schwartz, a personal injury and workers' compensation lawyer who does not often practice in federal court, found himself researching a bankruptcy issue under the Montreal Convention in 1999. Have you no paralegals? Why the fuck is the personal injury workers' comp lawyer who doesn't practice in federal court researching bankruptcy under the Montreal Convention? You know what I need from the Montreal Convention? I need more all-dress chips. That's not true. I have a bunch of them. Don't send them. I have them. But I need these to be available in the US. Can we make that a rule under the Montreal Convention? ChatGPT, get me all-dress chips in the US. The Ruffles ones. I know Aldi has like a facsimile of them. It's not the same. It's not the same. Okay. Those were from my lunch yesterday. They're not just in my office for dramatic effect. He also found that his firm's fast case subscription no longer worked for federal searches. With no Westlaw or LexisNexis subscription, he turned to ChatGPT. What the fuck is happening? Your law firm has no legal research tools at all? Not one. What is happening here? I don't practice. I do legal commentary, and I have access to legal research subscriptions that I pay for. I'm not taking money from clients to go into federal court with no tools. What are you doing to your clients? You're taking money from people to do what? Unless Lexis or Westlaw wants to sponsor me, I'm a free agent. You want to give me a deal? I'll come. I'll go. Just, you let me know. Not sponsored. I just pay for it myself. Julia, yeah, they're fucking expensive too. And it depends. The whole like legal research tools situation is a whole thing. I think it's less expensive than buying all the books every year. But nothing. They have nothing. No fast case subscription for federal case law. There's all and no Westlaw or LexisNexis subscription. He turned to ChatGPT, which he understood to be a highly touted research tool that utilizes AI. He did not understand it was not a search engine, but a generative language processing tool primarily designed to generate human-like text responses based on the user's text input and patterns it recognized in data and information used during its development or quote-unquote training, with little regard for whether those responses were factual. Given that the technology is so new and the press coverage so favorable and the warnings on ChatGPT's website so vague, particularly at the time Mr. Schwartz used it. Yeah, they're different now. His ignorance was understandable. But Your Honor, he didn't know. Well, especially in the light of hindsight, he should have been more careful. You doubled down, though. Boo. He should have been more careful and checked ChatGPT's results. He certainly did not intend to defraud the court. Then don't submit them again. A fraud that any lawyer would have known would be quickly uncovered, as this was. Your Honor, we are not thoughtful we're not careful, and we're cheap and not paying for Westlaw, Lexis, or the federal fast case subscription. If you can't do research on federal law, why are you taking cases in federal court? When it gets removed to federal court, refer it out to another firm. Oops-a-doodle. We thought, Your Honor, we thought it would be fine. It's not. Your sanctions are going to cost you more than a Westlaw subscription. That's my guess. Oh, boy. I scrolled because I got annoyed. What happened? What did I do? Fraud. There was no subjective bad faith here. The doubling down. The court is going to look at the doubling down, not the initial submission, but the second submission. Nor was there any misconduct related to the notarization of the April 25th, 2023 affidavit. Mr. Schwartz and his associate Peter LaDuca have sworn under oath that the affidavit was created on April 25th, that Mr. LaDuca signed it and Mr. Schwartz is present, and that Mr. Schwartz signed it and affixed his notary stamp to it the same day. The fact that the notary portion of the affidavit says it was dated January rather than April resulted from a clerical error. This is not sanctionable. Oops. We also got the date wrong, but it is Schwartz's notary stamp. Finally, sanctions would serve no useful purpose. Okay. Mr. Schwartz and the firm have already become the poster children for the perils of dabbling with new technology. Their lesson has been learned. Your Honor, the mockery of the internet is enough. I think the court is going to find that that's not persuasive. The firm has taken and is taking a series of remedial steps, obtaining better research tools for its lawyers. You just have to pay for them. Like they're in the computer. The files are in the computer. Implementing firm-wide CLEs and technology. If you would like to pay me, I'll come in and teach a CLE on technology. I've got you. I will make jokes, though. I don't know if you're here for that. Imposing policies against using AI tools without checking. This shouldn't need to be in a CLE. This is common sense and ethical practice. At this point, any additional sanctions the court imposes will be merely and unnecessarily punitive. I swear we didn't mean to, Your Honor. No, Mom, I swear. We didn't drive all the way to Diamond Bar to see those boys that we met that one time at a concert. I would never drive the car that far without telling you. Sure, Jan. Relevant factual background. Respondent's background. Stephen A. Schwartz is a member of the firm and has been practicing law in New York since 1992. Declaration of Stephen A. Schwartz, dated June 6, 2023. We're going to get there. Mr. Schwartz graduated from SUNY Albany. I almost said Alabama. Damn it. SUNY Albany in 1988 and received his JD from New York Law School in 1991. Schwartz has worked his entire career for the firm, where he practices in the areas of workers' compensation and personal injury on behalf of injured claimants under New York workers' compensation law. That's very specific. Because his practice is mainly limited to state court and administrative bodies, he's not a member of the bar of this court and rarely appears here. Then he shouldn't be dealing with any of this. Peter LaDuca received his law degree from St. John's University in 1985 and has been employed as an associate at the firm since 1996. Declaration of Peter LaDuca. Neither Schwartz nor LaDuca have ever been disciplined by any court or tribunal. Well, they've never done anything this fucking stupid, apparently. This is terrible. The law firm is a small firm based in New York City that focuses on workers' compensation and personal injury matters in New York State courts, as well as before the New York State Workers' Compensation Board. Then when your case gets removed to federal court, bring in other attorneys. I know that means you make less money, but the clients should come first. The firm and its lawyers do not regularly litigate in federal court. Then don't. The firm has never been subject to discipline sanctions in any proceeding. The instant action and defendant's motion to dismiss. I'm so interested to see their framing. On July 28, 2020, plaintiff Mata filed a summons and complaint through counsel in the Supreme Court of New York. He suffered personal injuries while aboard a flight. Mr. Mata's primary counsel was Schwartz, who filed, we know all this. The state court action was automatically stayed when the airline filed bankruptcy. On January 31st, 2022, after the bankruptcy had concluded, the automatic stay lifted. The parties agreed to voluntarily discontinue the state court action so that it could be refiled. 2 days later, on February 2nd, 2022, Mata, with Schwartz still as his counsel, refiled the action in state court. On February 22nd, 2022, the airline removed it to federal court pursuant to 28 U.S.C. 1441. Upon removal, Schwartz, who is not a member of this court, could no longer appear as counsel of record. That's when you bring in another attorney. Mr. LaDuca, who's a member of this court, appeared instead, while Mr. Schwartz continued to work on the matter and handle substantive legal research and writing. The airline moved to dismiss the claims as time barred by the 2-year statute of limitations period set by the Montreal Convention. Now, that's an interesting question because there was a bankruptcy and the bankruptcy stayed the proceedings, and the statute of limitation should be stayed during the time that the bankruptcy proceedings are stayed, not told. But if you don't have the research tools, you need to go to your firm and be like, we either need a research attorney, we need research tools, or this needs to go to somebody else. Respondent's opposition to the motion to dismiss. Respondents submitted an affirmation in opposition to the motion to dismiss, in which they argued that claims were timely filed because either 1, the Montreal Convention did not preempt New York's 3-year statute, 2, even if the convention's 2-year statute applied, the claims were still timely filed. The affirmation in opposition to the motion to dismiss was prepared by Schwartz and signed and filed by LaDuca. In drafting the opposition papers, Schwartz attempted to perform legal research on the interplay between U.S. bankruptcy law and the Montreal Convention, an issue with which he is not familiar. Clearly. Most people wouldn't be. It's highly specific. The firm's primary research database is Fastcase, an online research subscription that is available to all lawyers at the firm. The firm does not maintain a subscription to Westlaw or Lexis, as they are much more costly. Prior to this incident, the firm was under the impression that it maintained a subscription to Fastcase that allowed its lawyers to search both state and federal cases. You can call your Fastcase rep and be like, hey, we'd like to give you more money. And they'd be like, great. However, when Schwartz attempted to conduct research on Fastcase for this matter, he was unable to access the federal database. What should happen next is that he then called either another member of the firm or the Fastcase rep and said, yo, I don't seem to be able to access what I need to access. That didn't happen. The firm later learned that because of a billing error, the firm's Fastcase access to the federal court database had been inadvertently deactivated. Footnote 1. To be clear, the firm was able to access some federal cases through Fastcase. What the fuck? Was your Fastcase federal access deactivated, or were you able to use it? They're blaming everything but them. The federal case database had been inadvertently deactivated. If it had been deactivated, you wouldn't be able to access anything. But the footnote says, actually, we could access some federal cases through Fastcase, which is why it was able to provide 2 of the requested cases. However, the limitation made it so that Mr. Schwartz and the firm's lawyers could not run full-fledged searches for federal cases. If you put a case citation into Google, though, you can generally pull up the case in Google. You might not be able to read all of it on free websites, but you could see if it offers. The firm has since rectified the issue. They fixed the billing issue and made it clear to all its lawyers that they're able to access both databases. Yo, please don't fucking access ChatGPT. Please. Mr. Schwartz uses ChatGPT to assist with legal research. Tell me more about how we got here, please. Oh, Sheila, yes. It wasn't me is a legal defense as well as a defense in criminal law. The Shaggy defense is knows no bounds, actually. The limit does not exist to it. Wasn't me. Caught me on that ChatGPT. Because Mr. Schwartz's fast case access was limited, he turned to ChatGPT to conduct additional legal research. As detailed below, Schwartz did not fully understand ChatGPT, but was like, fuck it, let's ride. Schwartz had never before used GPT for legal research. He knew of the technology from his college-aged children. They're in federal court blaming this lawyer's kids. I'd be so fucking mad. I would be so mad. Are you kidding me? You're going to work in front of the federal court blaming your children? Oh my God. Oh my God. I can't even. So this one time, in the very busy preliminary hearing court that I was working in, a defense attorney was in court with a newfangled technology cell phone that would play songs as a ringtone because this was novel technology at the time. This was pre-iPhone. And his phone went off playing Miley Cyrus's Party in the USA. So I put my hands up. Yeah. Party in the USA. And the judge from the bench was like, immediately no. Immediately no. Counsel. And he is digging through his briefcase trying to find his phone. And he's like, Your Honor, my kids keep changing my ringtone and I don't know how to silence my phone. It was just delightful. Could not figure out how to silence the phone. But I actually believe that the kids were probably fucking with their parent and kept changing their ringtone because they couldn't change it back. But it's not, at some point ask them how to silence it when you know you have to go to court or leave your cell phone in the car. Anyway, Your Honor, my kids. My kids, Your Honor. He knew of the technology from his college-age children who probably would have said it's not reliable. Schwartz also remembered reading several articles touting the benefits of AI tools and their use in professional settings, including at law firms. Indeed, as discussed below, during the early part of 2023 when Schwartz conducted this research, such articles were ubiquitous in the legal and public press, with some predicting that AI tools such as ChatGPT could make legal research obsolete. Footnote 2. But Your Honor, we read an article that said ChatGPT was a lawyer. It passed the bar and legal research wasn't even a thing. You just type it into the computer and it just spits out all your work for you. So we don't have to do anything but take client money. Is that what they're trying to say? Footnote 2, a small but representative sample of these articles is attached to Exhibit A to the Declaration of Ashley Alger. Yeah, they are. There's a fuck ton of them. Oh, yeah, the college-age kids are not thrilled at all. Mr. Schwartz, therefore, decided to use ChatGPT to find additional support for his arguments under the Montreal Convention. Mr. Schwartz approached this task the way a lawyer would generally approach a research project, using a standard database, unaware that ChatGPT involved a very different technology. He first asked a broad question about tolling under the Montreal Convention and then asked a more targeted question and requested case law Schwartz declaration. We're going to get there. Footnote 3. A full history of Mr. Schwartz's ChatGPT conversation is included as Exhibit A to his declaration. Oh, yes, we're doing that too today. The mods are like, this one's going to be long. Accurate. Because the Supreme Court did things, and I wanted to talk about that too, but accurate. We're going to go through the entire printout from ChatGPT. ChatGPT answered, quote, there are several U.S. court cases that have held that the statute of limitations is tolled by the bankruptcy of a defendant pursuant to the Montreal Convention. Here are a few examples. ChatGPT is a people pleaser. It just wants to be liked. It will tell you anything that you want to hear so that you're happy with it. Oh God. Is it Raquel? Is Raquel ChatGPT? I have questions. No, sorry. Raquel decided that she was going to stop people pleasing and start pleasing herself. May I suggest adamandeve.com and not your best friend's man? Just saying. DM me if you want suggestions. ChatGPT listed 3 cases as quote unquote examples for this proposition, complete with case citations, summaries, and lengthy, very favorable quotations. Your Honor, the cases were so good for us, we had to use them. They're very, very favorable. Each time Schwartz asked for a specific case support, ChatGPT answered, certainly. The exclamation point. Certainly. And would provide Schwartzy with what is said was a brief excerpt from the opinion. For example, in response to Schwartzy's request to, quote, show him the Varghese case, ChatGPT responds, certainly. Here's a brief excerpt from the opinion of the United States Court of Appeals for the 11th Circuit, Varghese versus China Southern Airlines Company, Ltd. ChatGPT providing brief excerpt from this other case and another case. They're not helping themselves. This is getting worse. Certainly, Your Honor, the robot said yes, emphatically, with an exclamation point. Oh, we might need to make certainly merch. Yep, they're really admitting all of this. It keeps going. It just keeps going. They did. They also told him he was a pretty, pretty princess. ChatGPT is legalese hard. Certainly. Oh boy. This is a delight. Today is a delight. Thank you to the, 7,000 of you that have been hanging with me to wade through ChatGPT and these lawyers, because at some point we just needed a little bit of comedy on these streams, and tomorrow we got to get back into like gag orders and shit. So today I'm living for these lawyers being like, but Your Honor, ChatGPT said certainly. Oh, the analogies to be drawn. Emily, stay focused. Okay, as noted, Schwartzy did not fully understand how generative pre-trained transformer technology worked. Leave Bumblebee out of this. Mr. Schwartz believed that ChatGPT was a search engine, similar to Google or even a search database such as Westlaw or LexisNexis, that provided answers to questions using natural language based on publicly available information, including publicly available case law. Schwartzy recognizes now that this is incorrect. He had no idea at the time, however, that in response to a question, ChatGPT could generate an answer that, while intended to converse with and inform its user, was complete fiction and a cleverly devised fiction to boot. Footnote 4. See James Vincent, OpenAI isn't doing enough to make ChatGPT's limitations clear at The Verge. noting that the media often fails to convey the inaccurate nature of such platforms and that ChatGPT's disclosures are inadequate to warn users well. Nor did the warning on ChatGPT's homepage that ChatGPT may occasionally generate incorrect information alert Mr. Schwartz to the dangers. When you open it, it should just say, danger, danger. That statement could apply to virtually any web searches. It hardly would lead a reasonable person to believe that technology would make cases up out of whole cloth. We understand that the first time someone uses ChatGPT, additional warnings appear. However, given that Mr. Schwartz had once or twice before used ChatGPT for leisure while his children were showing him the program, it is likely that those same warnings did not appear. Mr. Schwartz has no recollection of seeing those warnings before using ChatGPT for research. It's a cleverly disguised fiction to boot. Had he known that, he certainly would not have used the technology for these purposes. The April 25th affidavit, oh boy. In its reply brief, defendant's counsel stated that it could not locate several cases cited in respondent's opposition. Yeah, because those cases were immediately on point and helpful, and they were like, what the fuck, where are those? Footnote 5, 6 of the 10 cases cited in respondent's opposition. 6 of 10. The other 4 cases were quoted or mentioned in one of the cited cases. That sounds like 10 of 10. On April 11th and 12th, this court ordered Mr. LaDuca to file an affidavit annexing 8 cases that defense counsel could not locate. Mr. Schwartz and Mr. LaDuca prepared an affidavit in response to the court's orders, which LaDuca filed on April 25th. We went over it on Tuesday. The April 25th affidavit purported to annex copies of 8 cases listed. Yeah, they did. They did purport to annex the copies, and they filed it and notarized it. And they're officers of the court. It did do that. It did exactly that. It gave them to the court and said, hey, here are the cases. Mr. Schwartz printed 2 of the 8 cases from Fastcase and returned to ChatGPT for the remaining 6 cases. Again, at this time, Mr. Schwartz was under the misimpression that ChatGPT was a reliable search engine, not an experimental project in generative AI. Mr. Schwartz therefore asked ChatGPT to provide copies of the 6 cases, which Schwartz and LaDuca annexed to the April 25th affidavit. The April 25th affidavit acknowledged that the opinions for the 6 ChatGPT cases, quote, may not be inclusive of the entire opinions, but only what is made available by online database. What online database? As detailed above, Mr. Schwartz did not have immediate access to a more comprehensive research tool. That's not the court's fault! Your Honor, They literally just said to the federal court, we have a client and we are practicing in federal court and we just didn't have access to any more cases because we're just not spending the money on these databases because they're expensive. So we're just practicing law out here while willy-nilly and in federal court. And we couldn't check our work. I'm sorry, Professor. I couldn't complete my assignment because, she didn't do hers. My bad. You're charging clients. This dude's been practicing for 30 whatever years. And they're just we just won't check it. Whoopsie doodle. This court better say, okay, Muffin, here's your sanctions. Because we're letting lawyers just fucking wild out here. What the hell? Your Honor, we did say that the 6 opinions, may not be inclusive of the entire opinions, but only what is made available by online database. You didn't clarify what online database. You didn't clarify that you couldn't find them anywhere else. You didn't tell the court that you also had questions. What you said to the court was here. And that's why they're going to get sanctioned. As detailed above, Mr. Schwartz did not have immediate access to a more comprehensive research tool. That's not the court's fucking problem. Do you think this client turns around and sues them for malpractice? I say yes. Your Honor, we didn't have Westlaw or LexisNexis or even a fast case subscription. How is that the court's problem? That's your problem. You're running a law firm. Nevertheless, he reasonably believed that ChatGPT was providing results based on publicly available information. Schwartzy was like, haha, I found a free way to access these databases so we don't have to pay for them. Yay. We'll just end run. Like if he really thought that ChatGPT just had like a backdoor to Lexis and Westlaw, is he thinking that they're just like end routing legal research and they're like, oh, we can get there free? Why would we pay for Lexis, Westlaw, and Fastcase if ChatGPT will just give it to us for free? That's a you problem. This is not the problem of the court. The level of them telling on themselves. This is what the court is going to find to be willful and in bad faith. You never even checked. We didn't have a subscription. Oh, okay. Yeah, ask me if a federal judge gives a fuck. My guess is going to be no. My guess is going to be no. He believed that ChatGPT was providing results based on publicly available information and had no intention of misleading his adversaries or the court. Your Honor, the case law was just too good. I couldn't stop myself. The holdings were directly on point. It felt like a win. ChatGPT gave me the attention that I was so desperately seeking, Your Honor. And I didn't even have to pay for it. Ugh. Indeed, the ChatGPT cases were not immediately suspect. You could have, for example, for the case of Varghese, the attached document included a case caption indicating the decision came from the Court of Appeals for the 11th Circuit, a docket number that at first glance tracks the format of circuit court appellate case numbers, a listing of 3 judges, footnote 7. Of the 3 judges listed, the first 2 sit on the 11th Circuit and were active on the date listed. So, are you telling me that Judge Higginbottom is the made-up judge? That it was Jordan and Rosenbaum that are the real judges, and Higginbottom was the fake one? That ChatGPT just made up a 3rd judge? Okay. The first 2 are circuit judges. The 3rd judge, Higginbottom, is a 5th Circuit judge. Oh, real judge, wrong circuit. However, the opinion shows an asterisk next to Judge Higginbottom's name, which could reasonably suggest that he was sitting by designation. Your Honor, it seemed legit. It seemed fine. It all seemed fine, Your Honor. The holdings were so good, we really wanted to use them. We did not want them to be not available to us. Another document purporting to be Peterson versus Iran Air indicated that the decision was issued by the United States District Court for the District of Columbia. The court was listed at the top of the page, listed the issuing judge, a current district judge for the District of Columbia, and contained both a federal reporter citation and a Lexis citation. The remaining attachments to the affidavit contain similar indicia of authenticity, including case caption and the identities of judges and lawyers involved in the case, and internal citations. Schwartz and the firm now recognize that the courts and their adversaries' inquiries should have been a red flag. What? Are you saying that you went running through the red flag? It is a red flag. It's all of a red flag. Your Honor, we're Raquel. We're running through the red flags right into Sandoval's arms. Red flag, red flag, red flag, red flag. All the red flags. We now recognize this is giving Raquel at the reunion. We should have just handled it better, Your Honor. I realize, Andy, that we didn't handle it great. Why the fuck is my robot vacuum in my hallway? It's so loud. Oh my God, I have to go murder my robot vacuum. Hold on. I promise I'll be right back. If I'm not right back, the robots have taken me. Fucking robot vacuum. Give me 30 seconds. Ugh. Robot overlord vacuum. I don't even know how it got into the door to my office. It was like, stop slandering my people. Freaking robot vacuum. Okay. My robot is upset. My robot's mad at me. It was so loud. Miguelina is like, we can't hear it. I could hear it. I couldn't think it was so loud. That noise, it just, oh. All right. Woo. The robot vacuum. I love this. Okay. The Roomba is spying for ChatGPT. ChatGPT can just spy on me directly on YouTube, though. It doesn't need to enlist my robot. All right. Let's see. Mr. Schwartz, the firm, now recognized that the court and their adversaries' inquiries should have been a red flag. It's giving Raquel reunion vibes. And they should have taken more affirmative steps at that point by contacting the law library or a colleague with Westlaw and LexisNexis access. We should have done something. Oh, and now my in-ears are just like cranky. To check ChatGPT's results instead of going back to ChatGPT itself. Correct. Yet their explanation is simple and reasonable. It seemed inconceivable to them. Fucking hell. Inconceivable! Your Honor, it's inconceivable that ChatGPT's results were complete fabrications. Your Honor, this whole thing, Your Honor, hindsight is 2020. We should have handled this better. But it was inconceivable that the results were complete fabrications. Oh. I don't know what else. I don't know why they're. I don't know. I guess they have to try to defend themselves and be like, but Your Honor, seriously, we had no idea that this could happen. But I don't think but we didn't pay for a Westlaw subscription is going to be the defense they think it is. It's just like Raquel being like, but I hate lying. Not the defense you think it is. On April 26th, defense counsel filed a letter noting that it still could not locate many of the cases. On May 4th, the court issued an order, the first OSC, which I covered Tuesday, in which the court observed that 6 of the proffered cases appear to be fabricated. The first OSC directed LaDuca to show cause why he should not be sanctioned for providing 6 decisions which did not exist. When he read the first OSC, Schwartz finally realized there had to be a serious problem with the tool he used to conduct legal research. Footnote 8. Mr. LaDuca did not personally conduct any of the legal research involved in the affirmation or opposition to the motion to dismiss, nor did he have personal knowledge of how the research was conducted by Schwartz. He just signed the thing. Your ass is still on the line. You're the one who's proffered it to the court. When he read the first OSC, Schwartz finally realized there had to be a serious problem with the tool he had been using. Schwartz immediately conducted further research into ChatGPT and learned that it was inherently unreliable for anything related to legal research and analysis. If it's too good to be true, like your holdings, it probably is. As part of this process, Schwartz submitted additional queries to ChatGPT. Schwartz, you wouldn't lie to me, would you? ChatGPT, never. Those cases are real. What we have here is real. I'm real. Those holdings are totally real. Ask Judge Higginbottom. It's all real. Oh my God. For example, he asked ChatGPT whether Varghese, which at that point Mr. Schwartz understood did not exist, was a real case. ChatGPT confidently answered, yes, Varghese is a real case. And I'm a real boy. Good God. We've gone full Pinocchio, folks. Mr. Schwartz asked ChatGPT to verify its sources for Varghese. So now he's cross-examining ChatGPT. Delightful. Mr. Schwartz asked ChatGPT to verify its source for the Varghese case. ChatGPT doubled down, just like they did with the court, and stated that the case does indeed exist and can be found on legal research databases such as Westlaw and LexisNexis. Mr. Schwartz did not submit these questions to ChatGPT for the purpose of trying to convince the court that ChatGPT case existed. Rather, knowing he had made a mistake, he wanted to show the lengths to which ChatGPT would go to mislead him, something he never expected based on his understanding of the technology. Oh my God. In response to the first OSC, Mr. LaDuca submitted an affidavit, which included an affidavit from Schwartzy. Mr. LaDuca stated that Schwartzy was primarily responsible for conducting the legal research. He did it, Your Honor. I just signed my name to it and my bar number. I didn't do it. He did it. I just signed the shit. Also a bad plan. Mr. LaDuca stated Schwartz was the primarily responsible for conducting the research and drafting the opposition, though he does not practice in federal court, to the original motion to dismiss and was responsible for finding the ChatGPT cases. I'm guessing none of them have paralegals to save them from themselves. Mr. LaDuca further attested that owing to his long professional relationship with Schwartz, as well as Schwartz's seniority and position at the firm, Mr. LaDuca had no reason to doubt the authenticity of the cases that Schwartz provided. Your Honor, legalese is hard, bro, but he's a partner and he said it was fine. Oh my God. So LaDuca is throwing Schwartz under the bus because Schwartz did this, even though it's LaDuca's fault because he signed it. LaDuca is throwing Schwartz under the bus, and Schwartz is throwing everyone under the bus, including his own children, or at least the law firm is. The Schwartz affidavit confirmed that Schwartz was solely responsible for drafting the opposition to the motion to dismiss and conducting legal research. Schwartz further confirmed that he had located the 6 non-existent cases using ChatGPT, which he did not know was unreliable. Schwartz acknowledged that it was his fault for not confirming the sources provided by ChatGPT, but it was not his intention to mislead the court. We meant to tell you before the reunion. Mr. Schwartz further attested that he greatly regrets having utilized generative AI to supplement legal research performed herein and will never do so in the future without absolute verification of its authenticity. The shit's out of the horse on this one, though. On May 26th, the court issued an OSC directing Schwartz and the firm to show cause why they should not be sanctioned. He did not meet the minimal standards at all. Matt, the future ESQ, are these ChatGPT hallucinations? Yes, apparently it just hallucinates all its own case law. It's real easy to win an argument when you get case law directly on point that's completely made up. Whoop. The relevant case law. In order to impose sanctions here, the court must find that respondents acted with subjective bad faith. The standard is the same whether under Rule 11, Section 1927, or the court's inherent authority. And then they go through the standard for subjective bad faith. The policy rationale behind the heightened standard for sua sponte sanctions makes sense. Unlike with a motion under Rule 11, Rule 11C3 does not afford a respondent the benefit of a 21-day safe harbor period to withdraw the allegedly frivolous pleading. As detailed above, as soon as the court issued the first OSC, respondents recognized their error and were forthcoming with the court. They should have been forthcoming when the court said, provide an annex. They let it get pretty far down the fucking line. If this had stopped with the annex, I don't think the court would have filed the OSC. Although respondents arguably should have realized their error sooner, this was not a scenario where they had the benefit of safe harbor as contemplated in Rule 11. Accordingly, the subjective bad faith standard reserved for Rule 11C3 is appropriate here. As this court has previously held, subjective bad faith in the context of sanctions requires the court to find that respondents acted with actual knowledge that the conduct was frivolous. I can't wait to see what the court rules on this. 1927 and the court's inherent authority. Section 1927 provides courts the power to sanction attorney conduct that is unreasonable and vexatious, that leads to multiplications of proceedings. Sanctions under Section 1927 are intended to deter unnecessary delays in litigation, but are only proper where the attorney's actions are so completely without merit as to require the conclusion that they must have been undertaken for some improper purpose. This is going to be next week's podcast, by the way, when we get back to Murdaugh and what's going on in the litigation with regard to Murdaugh admitting liability in the settlement with the Satterfield sons. Implicit to Section 1927 is the requirement that a party engage in some intentional wrongdoing that wastes time and resources of the court and the parties. Well, to impose sanctions under 1927, the court must find that the attorney acted in bad faith. The court's inherent authority to issue sanctions, which stems from the court's need to manage its own affairs and effectuate the orderly and expeditious disposition of cases, is likewise only appropriate where there is a particularized showing of bad faith. The court asked for the cases, it went back to ChatGPT and then printed out fake cases and gave them to the court. I don't know what else you do with that. The Supreme Court has cautioned that the court's inherent authority should be exercised with restraint and discretion. These lawyers just admitted to the court that they never checked it. It was all fine. And that sanctions are proper only when the party being sanctioned acted knowingly in bad faith. Inherent authority sanctions are inappropriate unless a party knowingly submitted a materially false or misleading pleading or knowingly failed to correct false statements as a part of a deliberate and unconscionable scheme to interfere with the court's ability to adjudicate a case fairly. They are trying to save their own asses. I think the doubling down, the court could find bad faith. They're saying, no. We just realized our error way late. Randomizer, this is exactly it. Your Honor, we weren't acting in bad faith. We're just willfully ignorant to the limitations of ChatGPT. So they are arguing that this is not bad faith. This is just stupidity. Whoopsie doodle, Your Honor. Sanctions are not warranted because respondents' actions were not in bad faith. This court should decline to impose sanctions because respondents did not exhibit subjective bad faith. The absence of bad faith is evident for at least 3 reasons. First, Schwartz's actions were based on a fundamental misunderstanding of what ChatGPT is and how it worked. That's not the court's problem. As detailed below, Schwartz legitimately thought that he was using new state-of-the-art search engine, not an artificial language program. He had no idea this program would fabricate case law. Then don't use it in federal court. Oops. Could you imagine a doctor being like, I thought this was just some new technology. I didn't mean to kill you. I mean, the results here aren't as bad, but I think the court's going to sanction them. Amanda said, did he just okay boomer himself with that phrase? Yes. 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 He had no idea this program would fabricate case law and certainly was not trying to mislead the court or knowingly engage in frivolous or vexatious conduct. Second, Schwartz could not reasonably have been expected to know that ChatGPT would make up entire cases and then continue to lie to him even after he questioned. Wait, I was on a roll, and then this sentence structure fucked it all up. Schwartz could not reasonably have been expected to know that ChatGPT would make up entire cases and then continue to lie to him even after he questioned its results. Grammarly would have caught that error. Third, Mr. Schwartz promptly acknowledged his mistake. No. False. Don't lie to me. Don't lie to me. Because there's no way this was prompt. The first red flags are what was prompt. Chris Mullen, but Your Honor, ChatGPT lied to me. This reminds me of every case I've ever seen where people get prosecuted for engagement with people who are underage. It's the exact same excuse, perpetrated in exactly the same way. Vastly different circumstances, but it's like, but they lied. How am I? I am a victim, Your Honor. I am a victim of the AI. It lied to me. It lied. Your Honor, I questioned the results and it said, certainly. It was just so kind. Or to go back to the affair, he told me they weren't together anymore. Raquel seemed most mad at that reunion, by the way, that Sandoval was still engaging in a relationship with Ariana. That's what Raquel seemed most bothered by. That they still seemed to have a relationship going on and they were still intimate after he and Raquel started being intimate. That's what she was most mad about. But Your Honor, the AI said it was fine. Third, Mr. Schwartz promptly acknowledged his mistake as soon as he realized what had transpired. These actions are inconsistent with evidence of bad faith behavior. This judge is going to lose their mind. Schwartz might also lose his license. For sanctions to issue, the court must find Schwartz knew that he was submitting fictitious cases to the court, either in the original affirmation in the opposition or the affidavit. Proof of actual knowledge and not merely what a reasonable attorney should have known is required to satisfy the subjective bad faith standard. The court might find that that standard doesn't apply. As detailed above, Schwartz did not know the ChatGPT cases were fictitious. On the contrary, because he did not understand how ChatGPT worked, Schwartz believed that ChatGPT had gathered legitimate cases from publicly available sources. Those are all paid sources, though. He did not think for a second that he was using a technology that was capable of fabricating information or lying to him about the authenticity of the information provided. This court's decision in Riveras is instructive here. In Riveras, this court ordered attorneys to show why they should not be sanctioned for filing notice of removal that was clearly prohibited under Section 1441B2. The attorney in Rivas, did I add an R in there? I might have. The attorney in Rivas were well aware that the section foreclosed their client's liability to remove the case, but filed a notice of removal anyway in hopes that plaintiff would not challenge it. In other words, the attorneys knew their actions were prohibited, but did it anyway. As a result, the court found the attorney's intentional conduct evidenced bad faith. Here, Schwartz's conduct could not be more different, as detailed above. Schwartz didn't know that ChatGPT cases were fabricated when he submitted them. Whoopsie. Schwartz's understanding of ChatGPT at the time that it was a search. Schwartz's understanding of ChatGPT at the time was that it was a search engine, not a large language model designed to simulate human conversation, regardless of the accuracy of the information. This is a common misunderstanding. The articles attached as Exhibit C make clear that this is one of the biggest risks. One of the biggest risks of this type of technology is that a significant segment of the population, including members of the legal profession, do not fully understand how it works or where it can go wrong. Then don't use it for client work. Your Honor, I didn't know that I should be more diligent. At the time Mr. Schwartz used ChatGPT to conduct legal research, the technology was the subject of almost daily discussion in the media and legal industry. The media lied to me, Your Honor. It's their fault. It's the media's fault. It's his kid's fault. It's everybody's fault. Double checking case law is literally your job. Like, not perpetrating fraud on the court is your job. It's how the system works. This isn't new. Go to the law library then and look them up. You had all the reporter numbers. Indeed, many articles circulating within the legal industry at the time focused on whether ChatGPT would revolutionize how lawyers and law firms operate and touted GPT as a legitimate tool for lawyers to use in certain circumstances, not to do legal research. Moreover, the history of Mr. Schwartz's interactions with ChatGPT in this case weighs against a finding of bad faith. As detailed above, Schwartz did not simply enter a single query into ChatGPT and paste the answer into his opposition. Instead, he used the technology, albeit incorrectly, as though it was a legitimate research tool. Schwartz asked for information about general legal issues, cases that stood for a proposition, and even copies of the cases that ChatGPT was summarizing and citing to. Each time, ChatGPT provided answers that appeared legitimate, or at least not obviously false. Indeed, even when Schwartz directly asked GPT whether the cases it provided were fake, the program not only said the cases were real, but assured Mr. Schwartz that the cases were available on Westlaw and LexisNexis. Your Honor, ChatGPT said it was fine. So there's no bad faith here because it told me it was okay. They italicized it. You guys. ChatGPT told me and assured me that the cases were real. At the time, Mr. Schwartz did not think he needed to doubt this assurance. Legalese is hard, bro. Wow. They said they were separated. Of course. Mr. Schwartz realizes in hindsight that he missed several warnings and should have taken other steps to verify the accuracy of the cases he was citing. Whoopsie doodle. For example, Schwartz recognizes he should not have tried to use GPT in the first place, a new technology with which he is unfamiliar. Instead, if the firm's fast case subscription was too limited for what he needed, he could have either asked the firm to purchase additional resources or taken advantage of the Westlaw access code at one of the Bar Association law libraries. Oh, look. Resources that were available to you. At least they're telling the court we had additional resources. We just chose not to use them. Your Honor, just punish Schwartz is kind of what they're saying, or his children. Similarly, or his cow. Similarly, Mr. Schwartz recognizes that as soon as the ChatGPT cases were questioned, he should have tried to verify the accuracy of the cases from an independent source. That, I think, is the kicker in this case. I think that's the part that's the problem. I think all of the explanations go to the first part, but once you get to the fact that the court and counsel are saying these cases don't appear to be legit, once you get there is where you have to verify them from an outside source. And I think that's why they get sanctioned. That. But again, because he believed that ChatGPT was acting as a reputable search engine and could not conceive it would simply make up that it would simply make up entire cases and citations, he did not immediately question the very foundation of how the technology worked. Although this may evidence poor judgment, it does not rise to the level of subjective bad faith or willful blindness. We'll see. Mr. Schwartz promptly acknowledged his mistake. Do you think he promptly acknowledged his mistake, chat? Yes or no? Immediate acceptance of responsibility is also inconsistent with the notion of a lawyer acting in bad faith. He doubled down, though. Here, in the response to the first OSC, it shouldn't have had to get to the first OSC. Here, in response to the first OSC, Schwartz and LaDuca promptly acknowledged their mistakes. It shouldn't have gotten to the first OSC. They should have acknowledged it before they submitted the annex. Schwartz took full responsibility for including the ChatGPT cases in the opposition paper and acknowledged he should have taken better care to verify the accuracy of the cases. You had one job. You had one job. Schwartz admitted that he should have familiarized himself with ChatGPT and its risks before using the tool. Now, in response to this order, Schwartz is providing a more fulsome explanation of how and why he came to use ChatGPT. He continues to own up to his mistakes. These actions are inconsistent with someone who submitted materials to the court in bad faith. The firm should not be sanctioned. Indeed, the firm believed that it had the research tools necessary for the assignment here. It did not know that its access to federal cases on Fastcase had been limited until it was too late. False. That's false. He knew that his was it midnight before your paper was due and you couldn't have fixed this? Like, how late were you on filing this thing? Were you rushing at the last minute? Because when he was researching the cases on Fastcase, he realized that he didn't have full access. Just fix it then. Just fix them then. But no, it was not too late. And even then, when Mr. Schwartz turned to ChatGPT, he did not know it would, in essence, defraud him. It's ChatGPT's fault. There is no violation and no reason for the court to use its power to sanction the firm. Mr. LaDuca's actions, it says, do not support a finding of sanctions. He just signed it. As demonstrated above and in Mr. LaDuca's May 25th sworn affidavit, at the time the papers were submitted to this court, Mr. LaDuca had a good faith basis to believe in the veracity of Schwartz's research, and his reliance on that research was reasonable. That is probably the best argument they have in all of this, is that Mr. LaDuca believed that his firm had done it right. Here, Mr. LaDuca understood that Schwartz, a seasoned and experienced attorney, had prepared the opposition in good faith based on research he had conducted online. Mr. LaDuca also believed that the propositions in the opposition set forth by Schwartz about the statute of limitations and the cases cited were entirely reasonable. Accordingly, at the time LaDuca filed the opposition, he had a good faith basis to rely on Schwartz's research. Moreover, even after opposing counsel informed the court that it was unable to locate any of the cases, any concern LaDuca may have had was addressed by the fact that Schwartz appeared to have located the vast majority of the cases, and at no time did LaDuca have any reason to even suspect that the cases Schwartz cited did not exist. Mr. LaDuca played a limited role in the submissions now at issue, but at all times took his role seriously and conducted himself honestly. He believed in the veracity of his submissions to the court, and his conduct therefore does not support a finding of sanctions. They acted reasonably. Did they act reasonably? They say they did. This is bold. 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 The court, is that even lawful law? ChatGPT, certainly. Here's the case. Even if this court somehow decides to eschew the substantive bad faith standard and examines whether the conduct was objectively unreasonable, I think that's where the court's going to get to. And objectively, was it unreasonable? Yes. Sanctions are still inappropriate. Tell me more. Looking at all the facts and circumstances, it was not objectively unreasonable for Schwartz to turn to ChatGPT or for him to accept and act on what he believed were accurate search results. Oh, God. I've never heard anyone say so many bad things, wrong things, all at once, in order. I need a meme. I need the meme. Oh, boy. Similarly, it was not objectively unreasonable for him to go back to ChatGPT to verify the accuracy of the cases. This is so for several reasons. First, as we have shown above, in February 2023, when Schwartz conducted his research, ChatGPT and other AI solutions were being widely hailed in the press as the future of lawyering. Your Honor! The media said it was true, and we relied on it. This attorney with 30 years experience is out here being like, but the newspaper said it was so I believed it. The media said it was great. Okay, sure. Much less was being written about its deep flaws and particularly about its tendency towards falsehoods. ChatGPT is a lying liar that lies, Your Honor, but it's a really good liar. We didn't know. I think it might be a narcissist, Your Honor. We don't know. It's not my fault. It's not my fault. I got gaslit by the narcissistic tools of computing. My bad. Oh my God. It's the media's fault. It's ChatGPT's fault. But it's definitely not these lawyers' fault. These lawyers, the lawyers whose job it is to do the thing, it's definitely not their fault. Nor did ChatGPT's website adequately warn about the risk. They should have told us, Your Honor. It said merely that the program may occasionally generate incorrect information. You're the lawyer. Read the warning. A warning that would be true of most any search engine or social media site. Footnote 11. Interestingly, when ChatGPT was asked the same questions earlier this week that Mr. Schwartz asked when he was preparing the affirmation in opposition, ChatGPT's answer included substantial disclaimers about the reliability of the information. These disclaimers did not appear when Schwartz conducted his research. Oh, yes, there were. There were substantial disclaimers. When I went through on Tuesday, there were substantial disclaimers. And then I asked if the disclaimers had been added, and the AI was like, I don't know. I don't know what's been added to me. I can't tell. Second, the research results appeared authentic on their face. The case name, docket numbers, and judges all looked proper. Though if you had put them into Google on the free search engines, they wouldn't have come up. Oh, they absolutely increased the disclaimers. Absolutely did. Indeed, when Mr. Schwartz asked ChatGPT to confirm its false results, it did so unabashedly. What morality are you trying to impose on ChatGPT? It's AI. It did so. It wasn't, Your Honor. The AI isn't even embarrassed that it was lying. It did so. Have you no shame, ChatGPT? What the fuck is this sentence? What is this sentence? When Mr. Schwartz asked ChatGPT to confirm its false results, it did so unabashedly. How are they writing this to the federal court that they have misled? How are they writing this? How are they here? How are we here? Oh my God. Your Honor, that shameless AI, it just unabashedly lied to our face. What? Stop trying to impose morality on ChatGPT. Are you fucking kidding me? ChatGPT's like, and legalese is hard, bro. It's much easier if you just make up the case results. You asked me for a result and I gave it to you. Isn't that what you wanted? Oh my God. Third, Mr. Schwartz resorted to ChatGPT only when he realized the firm's Fastcase account no longer allowed complete federal searches. That is the firm's. How is this their answer? How is this their answer? How is this their answer? But Your Honor, we had a billing error, so we couldn't do anything else. This is fucking wild. He did not have time to fully research the risks and benefits of this new technology. Oh, were you trying to do this the day before the answer was due? Also not the court's fault. Also not the court's fault. It is the funniest possible outcome for our purposes. The court, I think, is going to be less amused and more outraged at the lawyer's unabashed blaming of everyone else. He did not fully have time to research. Well, do your work sooner. I mean, I feel attacked. I'm ADHD. I need that last minute rush of adrenaline, energy, and focus. But that's why I don't like practicing in motion practice. It's why I liked practicing in court. Oh boy. Your Honor, we just didn't have time. We couldn't get it done in time, Your Honor. So sorry. Indeed, there was no clear body of knowledge that he could have called upon at the time to do so. They just said to the court, We waited so long to get our work done that we literally had no other option but to rip things off of ChatGPT and make AI write our brief for us because we waited. We did our jobs so badly that we had no other option. They're just making it worse for themselves because that's what they've told the court. We didn't even have time to fix the billing error. Didn't even have a day to reach out to Fastcase and say, hey, we need federal access. So what time of night was this being done at before this was due? That there was no time to fix it. Also, not the court's fault. Also doesn't make this any better. Makes it all the way worse. All the way worse. This technology was essentially brand new. Then don't use it for things you're fucking filing in court. Not one that Mr. Schwartz had ever used before. Your Honor, it's my first time. You sound like Josh Duggar. It's the first time I've ever downloaded anything like that off the internet. Whoops. I didn't know. Mr. Schwartz hadn't even used it before. These aren't his pants, Your Honor. And not one that he is likely to use again. Well, I believe. That I fucking believe. Your Honor, those weren't my pants. I don't know how that got in the pocket. See Simon's New York Rules of Professional Conduct annotated. A lawyer is not required to stay current with every new app and every form of technology. Addendum. Then don't use it. If you cannot adequately use the technology, don't use it. Yeah, you're not required to stay up on every single form of technology, but you can't use it and put it in a pleading to the court if you don't know how it works. You don't get to have it both ways. The proposed comment 8 does not require a lawyer to keep up with developments in technology. They're not relevant to a lawyer's own practice. These citations aren't helping you. Oh God, it gets worse. Oh God, it gets worse. Oh God, it gets worse. Keep reading. Mr. Schwartz called upon this new tool in a pinch, having to research a federal bankruptcy issue with which he was completely unfamiliar. Obviously, in hindsight, he used the wrong tool. This technological failure should not result in sanctions. They're making it worse for themselves. In short, Mr. Schwartz is not the first lawyer to be beguiled by new technology. Oh, that beguiling new technology. Ooh, it's her fault, Your Honor. Didn't you see how beguiling she was? I was lured in by ChatGPT. And then I said, you wouldn't lie to me, right, ChatGPT? And ChatGPT said, no, never. We'd never lie to you. What the fuck? They're attributing so many human aspects to ChatGPT. It's so fucking crazy. He was beguiled. This is like, just blame the woman, right? Blame ChatGPT. Your Honor, it was new and shiny. It was nice to me. It said nice things. I was enchanted. Oh my God. Just the absolute fucking audacity that they don't even see it. They don't even see it. The whole playing the victim because the technology was just, it was so beguiling. It wasn't, he was taken advantage of by ChatGPT. Yeah, the siren song, right? I'm so offended. I guess offended's not the right word. I'm dumbfounded. I'm dumbfounded by this. Dumbfounded that this is the answer. It was beguiling and it was an unabashed liar. Oh my God. Yep, he was seduced. It wasn't his fault for the siren song, Your Honor. Are we at Code Red yet? Yeah, this is Code Red shit. This is absolutely code red shit. For those of you that may be new here, this is fucking wild. We're going to DEF CON red because we need to. And in doing that, there will be flashes. So if you're flash sensitive, the flashes will end when the music ends. But I grant your motion for DEF CON red because that seductress ChatGPT lured in poor Mr. Schwartz, made him lie to the federal court. And then when he went back to ChatGPT and said, you wouldn't lie to me, right? It lied unabashedly. The fuck. We're going to DEF CON red in 3, 2, 1. I can't believe they're just trying to blame the beguiling ChatGPT. Look, I just how is this? ChatGPT is out here being like, here's your one chance, fancy, don't let me down. Here's your one chance, fancy, don't let me down. Hey, ChatGPT, be nice to the menfolk and they'll be nice to you. This is where we're at. All right. Poor ChatGPT. Scarlet lettered. In short, Mr. Schwartz was not the first attorney to be beguiled by new technology, and he will not be the last. These poor men. They just don't know. They do what they can. They're out here buying batteries and using ChatGPT, and it's not their fault when it goes wrong. Footnote 12. See Judge Dixon, my quote, hallucinating experience with ChatGPT, Judges Spring 2023. And then it lists the American Bar. What does this say? I'm going to have to read this later. My hallucinating experience with ChatGPT. The artificial AI powered software ChatGPT has amassed users at a faster rate than any other online platform. If they're talking in this article from spring of 2023 about ChatGPT hallucinating, then shouldn't he have known? Schwartz may be one of the first, at least as far as publicly reported decisions appear to show, to encounter a highly touted product that generated wholly fictitious results. Likewise, Mr. LaDuca acted reasonably in relying on Schwartz. Accordingly, no sanctions should be issued. The notarization was not fraudulent. Okay, the order also directs, I'm interested in this. Oh, I'm not sharing my screen. I'm sorry. My bad. Sorry, y'all. I'm in the rabbit hole. So this was the article from the American Bar. I will list this in the, I will list that in the description so you guys can have it. Ashley. I was high on ChatGPT. It's not my fault. Raise your hand if you've been personally victimized by ChatGPT. Alexandria said, they really think they did absolutely nothing wrong. No, they think it's like a little mistake. Like a little M mistake. Not a big mistake. The order directs Mr. Schwartz and the firm to show cause why sanctions should not issue based on the use of false and fraudulent notarization. The notarization here was legitimate. The April 25th affidavit was signed by Mr. LaDuca before Mr. Schwartz and then notarized by him, with Mr. Schwartz affixing his stamp. The document's metadata shows it was printed on April 25th, 2023, as the document indicated. Nevertheless, although the date April 25th, 2023, and the notary signature section states that it was notarized on the 25th day of January 2023, that was a typographical error. Your Honor, we just make mistakes. You know? We can only do so much. As detailed in the declaration of Mr. Schwartz, the April 25th affidavit was generated from a pre-existing document from another case so that they could maintain the affidavit formatting. Yeah, we copy and pasted and we forgot to change the date. That's what they just said. That's the fuck. Your Honor, we just copy and pasted. We forgot to change the date. Our bad. Oopsies. Just like we just copy and pasted from ChatGPT and forgot to check the veracity of the case law. We're just copy paste around here. Unfortunately, owing to a clerical oversight, the month in the notary section of the original document, January, was not changed to April before the document was printed for signature. Yeah, we get that you don't double check. We get that you don't double check. We understand that you don't double check. You've made that clear. Your Honor, we use January and April synonymously around here. It's fine. In addition, neither Mr. Schwartz nor LaDuca noticed the error. Obviously, the clerical error does not evidence intentional or bad faith conduct. Noting that an inadvertent mistake that erroneously implied the wrong date of agency publication does not justify sanctions. Sanctions are unnecessary. Tell me more about that. It's well established that the purpose of sanctions is to deter the specific conduct that gave rise to the sanctions inquiry, and that sanctions should be no more punitive than necessary. Your Honor, we've been punished enough. Here, any sanction would be unnecessary for at least two reasons. First, respondents have already taken significant remedial measures. Schwartz has spent significant time educating himself on the state of AI technology in the legal field and the need to properly verify any technological tools used to assist with legal practice. He has already completed one continuing legal education course on technology competence and the use of AI. Great. The firm has also taken prompt action to address the situation. Upon learning of the order, the firm immediately hired outside counsel with expertise in legal ethics and professional responsibility to help the firm implement a plan to address the issues raised in the order. Pay for your research tools. That's all. Your Honor, we need outside help. No, you don't. No, you don't. Stop cutting corners. In the short term, the firm has conducted an assessment of its legal research capabilities and has now made sure that every lawyer has access to both federal and state court research databases, as well as the necessary training resources to effectively use the databases. Most of those programs provide that for free. The firm is scheduling continuing legal education. We've heard this earlier. The firm has also scheduled an internal training to remind all lawyers and staff about the proper practices for notarizing documents, including the requirement that the notary and the signer verify the accuracy of the information in the signature section. Yeah, Your Honor, we got a little sloppy. We're sorry. Accordingly, any sanction for the same conduct would be duplicative and unnecessary to act as a deterrent. Second, the public scrutiny to the internet's been mean to us, Your Honor. Second, the public scrutiny to which respondents have been subject as a result of this court's order to show cause has been an effective deterrent for both respondents and others similarly situated. In the past week, there have been numerous articles, social media posts, and other online media about respondents in this case. Articles discussing or mentioning this court's order identifying Schwartz, LaDuca, and the firm by name. Oh yeah, they called all of you out by your name. All of you. Articles about respondents have already been circulated in law firms across the country as a cautionary tale. Oh, and the internet in general. And this answer is not helping. Respondents, and Mr. Schwartz in particular, have been publicly shamed for their supposed ignorance and carelessness. Shame! Their reputations and the firm brand have been irreparably damaged. To impose further sanctions on top of this would be unduly punitive and serve no useful purpose. I'm ordering a transcript from this hearing. I want to hear everything the court has to say. They didn't quote Heather Dubrow, though. The court should quote Heather Dubrow and say, sometimes when everyone says you're dead, you just need to lay down. But yes, Your Honor, stop. You are literally beating a dead horse. We have brought shame upon ourselves. It's so funny to me the way they're deflecting that the public is somehow at fault for this shame. Your Honor, the public's been mean to us. All right, where's Schwartz's? We need to go to Schwartz's. We need to go to Schwartz's affidavit next. Where is it? That's Catherine's declaration. This is the memorandum. This is the declaration of Mr. Schwartz. It's 28 pages long. I didn't mean to have the longest streams ever this week, but here we are. Declaration of Stephen Schwartz. I am an attorney admitted, for now, to practice in the state of New York and a partner at the law firm. I submit this declaration in response to the court's OSC dated May 26th as detailed below. I'm not going to read it word for word. Why? Because that motion pulled mostly from this. As detailed below and in the accompanying memorandum of law, I respectfully request that the court decline to impose sanctions against me, my firm, and my colleague. First and foremost, I want to deeply apologize to the court for citing cases that turned out to be fabricated and later submitting what I understood to be copies or excerpts of those non-existent cases. So, Your Honor, I fucked up and then I fucked up more. Oops. At the time that I performed the legal research in this case, I believed that ChatGPT was a reliable search engine. I now know that was incorrect. However, it was never my intention to mislead the court, and I regret not recognizing my error sooner. I apologize for the incorrect date on the notarized portion of Mr. LaDuca's affidavit. This was a typographical error for which I was responsible. I copy and pasted badly, Your Honor. All the way around. All the way around on this. Notwithstanding that error, the document was properly notarized contemporaneously with Mr. LaDuca signing it. I recognize, however, that I should have paid closer attention. To everything. To everything. Personal and professional background. I've been admitted to practice in the state of New York since 1992. We covered all this in the earlier thing. We covered that this is not his area of practice generally. We covered the prior sworn affidavit. In my prior affidavit sworn May 24th, I described my involvement in this case. I will not repeat any of that here, merely incorporate by reference. I will focus my decision to use ChatGPT in responding to the court's motion. It's everyone else's fault, Your Honor. The opposition in the motion to dismiss. After this case was removed to federal court, defendant filed a motion to dismiss. As a partner who had been lead counsel on this case in its inception for almost 3 years, I took the responsibility of preparing a response to the motion. Our position on the motion is that the claims were timely filed because either the Montreal Convention's shortened statute was inapplicable or, in the alternative, any period of limitations was told by the bankruptcy. Reasonable position. As discussed in our memorandum of law, as well as the declaration of Thomas Corvino, the firm practices primarily in New York state courts and administrative tribunals. Then bring in other lawyers. The firm's primary tool for research is called Fastcase. Based on my experience using Fastcase, I understood the firm had access to the state and federal database. I first attempted to use Fastcase to perform legal research on this case. However, it became apparent I was not able to research the federal database. On what date did you do that, though? Because why couldn't you just fix that error in a phone call? My use of ChatGPT. In an effort to find other relevant cases for my opposition, I decided to try to use ChatGPT. I'd never used ChatGPT for any professional purpose before this case. I was familiar with the program from my college-age children, as well as the articles I had read about the potential benefits of AI technology for legal. At the time I used ChatGPT, I understood that it worked essentially like a highly sophisticated search engine, where users could enter search queries into ChatGPT and it would provide answers in natural language based on publicly available information. I realize now that my understanding of how it worked was wrong. Had I understood what ChatGPT is or how it actually worked, I would have never used it to perform legal research. It's a bit late. Based on my erroneous understanding of how it worked, I used the program to try to find additional case law support for our arguments. And then you never verified them. Ever. Ever. I conducted the search in the same general manner I search any legal database. When? In connection with my research, I also asked ChatGPT to provide the actual cases it was citing, not just summaries. Each time, ChatGPT provided me with what it described as a brief excerpt. Okay. That was complete with a case caption, legal analysis, and other internal citations. I recognize in hindsight I should have been more skeptical when ChatGPT did not provide the full case I requested. Nevertheless, given the other features of the cases it was providing, I attributed this to the program's effort to highlight the relevant language. As noted above, when I was entering these search queries, I was under the erroneous impression that ChatGPT was a search engine, not a piece of technology designed to converse. The April 25th affidavit. In response to the defendant's reply brief, which stated that defense counsel could not locate several of the cases in our opposition, the court ordered Mr. LaDuca to file an affidavit annexing 9 of the cases. LaDuca sent me the court's order the day it was issued. I was unable to find one of the cases, which was cited within another case that I had found on ChatGPT. Of the remaining 8 cases, I obtained 2 of the cases from Fastcase. The remaining 6 I obtained from ChatGPT. Similar to how I used ChatGPT when I was preparing the op papers, I asked ChatGPT to provide copies of the cases, and it provided me with what appear to be partial versions of the cases. Seems okay, but I did not have another research database with access to federal reporters available to me. Yes, you do. There is a law library. You are a partner at a law firm, and you could have called up Fastcase and said, hey, not having access to a research tool when it is your fucking job is not the excuse here. I couldn't. I did not take these citations and obtain full copies of the cases from another source. I realize now that I could have gone to a bar association library or a colleague, but it did not occur to me at the time. Didn't even Google the case citations on Find Law. However, when I was responding, I still did not believe it was possible that the cases ChatGPT was providing to me were completely fabricated. Therefore, I attached them to the affidavit and signed it. Mr. LaDuca asked me to notarize the affidavit to prepare the affidavit. I used a Microsoft, so he notarized his own thing. I used a Microsoft Word file of an affidavit on another case in order to avoid having to format a new document. I just copy and pasted. The affidavit was from the other case, notarized in January 7th, 2011. So I changed the day from 7 to 25 and the year from 2011 to 2023. I neglected to update the month. This was a purely typographical error. The first OSC in my realization that ChatGPT cases were not authentic. In response to the April 25th affidavit, as well as a letter from defense counsel representing that it still could not find the cases, this court issued an OSC on May 4th directed to Mr. LaDuca. The first OSC stated that the court could not find any of the 6 cases. When I read the first OSC, I realized that I must have made a serious error and there must be a major flaw within the search aspects of the ChatGPT program. What's that like? What's it like when you are a 30-year professional, you make a staggering error to a federal court, and your first response is, the program must be broken? What is that like when he takes no responsibility on himself and just says, the program must be broken? What is that? I don't know what that's like. I don't live in that world. Because when I make the tiniest of error, I will routinely beat myself up about it for years to come. Like the day my child, now going into his sophomore year in high school, went to the first day of kindergarten, and I didn't realize that I was supposed to bring school supplies for the first day of kindergarten. I still have shame over that. Nobody told me. How was I supposed to know? It wasn't on the website anywhere. Everyone else just seemed to know. I didn't know. And I was fucking mortified. And you know what I did? I brought them the next day. I'm still mortified by it. Supplies. Kindergarten. What is it like to make a massive fucking professional error and turn around and blame everyone else but yourself? And just say, oops, my bad. I don't know what that kind of audacity is like, but I need some. How is this real? Can someone tell me what it's like to live like this? No, none of us can, because all of us are in the same boat. We don't live this way. God damn it. This is stunning. I realize I must have made an error and there must be a flaw with ChatGPT. Where does anyone get the fucking audacity of this dude? And it's or Murdaugh or Girardi. God, the fucking audacity. Runkle, you make me feel so much better. If I had screwed up this bad, I'd be moving into the forest to live as a goat. You would just walk in and turn in your law license and be like, here, it's time for me to stop now. Yeah, and he hasn't taken responsibility. He has said that he was tricked because ChatGPT said, certainly. And, it wooed him. He was tricked. It wasn't his fault. It was too alluring. That pesky ChatGPT. I have since come to realize, okay, Raquel, following the order that the program should not be used for legal research and that it did not operate as a search engine at all, which was my understanding of how it worked. It's not my bad. Before the first OSC, however, I still could not fathom that ChatGPT could produce multiple fictitious cases, all of which had various indicia of reliability, such as captions, names, judges, blah, blah. The first OSC caused me to have doubts. But you didn't doubt yourself. You doubted ChatGPT. As a result, I asked ChatGPT directly whether one of the cases it cited was a real case. Based on what I was beginning to realize about ChatGPT, I suspected that it was not. Oh, we're only at sus? We've only reached sus? However, ChatGPT again responded that Varghese does indeed exist, and even told me it was available on Westlaw and LexisNexis. Contrary to what the court and defense counsel were saying. This confirmed my suspicion that ChatGPT was not providing accurate information. You could have confirmed that suspicion by checking the cases, but go off, and was instead simply responding to language prompts without regard for the truth of the answers that it was providing. However, by this time, the cases had already been cited in our opposition papers and provided to the court. Did you immediately send a letter to the court apologizing? No. In an effort to be fully transparent, I blamed everyone but myself. I'm sorry. I provided an affidavit to Mr. LaDuca to submit along with his response to the first OSC. In my affidavit, I made clear that I was solely responsible for the research and drafting of the opposition, and I used ChatGPT for some of the legal research. Good distancing. Dervis, yes. ChatGPT is a siren of seduction. Clearly. I also apologized to the court and reiterated that it was never my intention to mislead the court. The consequences of this matter. I'm now beginning to realize how deeply I may have hurt people, and maybe I need to write the court a personal note because I'm just now having realizations that there's more consequences. Okay, sorry. I hallucinated VPR. The consequences of this matter. As detailed above, I deeply regret my decision to use ChatGPT for legal research, and it is certainly not something I will ever do again. I believe that sentence. I recognize that if I was having trouble finding cases on the firm's existing research platform, I should have asked the firm to obtain more comprehensive subscription or use the research resources such as Westlaw or Lexis maintained by the law libraries and bar association. Izzy, I think this is worse than a YouTuber apology. I think there's some YouTuber apologies better than this. For sure. Since submitting my response to the first OSC, I have already completed one continuing legal education course. In the past week, there's also been a significant amount of media coverage about the case, for which I and my firm have been publicly ridiculed. This has been deeply embarrassing on both a personal and professional level, as these articles will be available for years to come. Sir, the internet's forever. And this is it's giving Sandoval. We should have handled it differently. It's been really hard for me because everybody's like mad and stuff. Although I realized my actions were wrong. Oh, no. See, the although is the problem for me in this. Get rid of the although. I recognize my actions were wrong, period. Although I recognize my actions were wrong, they were not the result of any intentional effort to mislead or deceive the court. I made a deeply regrettable mistake. This matter has been an eye-opening experience for me, and I can assure the court that I will never commit an error like this again. I therefore respectfully request the court decline to impose sanctions in this matter. Please, Your Honor. I like my job. Exhibit A. What is happening? I don't know what's happening in the beginning part of this export. This was exported 6/5/23 at 4:24 p.m. ChatGPT monkey business refers specifically to the yacht that Gary Hart and former senator and presidential candidate boarded with Donna Rice in 1987. User, the quote, blackface scandal that encompassed Virginia's governor reminded reporters that when they are investigating the lives of public figures, they should remember to consult what resource ? Group of answers. What the fuck is happening? Okay. I don't know how we got here. ChatGPT. When investigating the lives of public figures, reporters should remember to consult multiple sources of information, including court records, news archives, public statements, and interviews with people and individuals. Why? What are they talking about leading up to this? And why? I am so confused. Okay. Tolling the Montreal Convention statute, user. What the fuck? User. Argue that the statute of limitations is tolled by bankruptcy of defendant pursuant to Montreal Convention. Oh. So the input is argue that the statute of limitations is tolled by bankruptcy of defendant pursuant to Montreal Convention. That's exactly what ChatGPT did. That's what they did. You asked them to argue and they argued. I don't know what the above search was. And I don't know why it's being researched. And I have a lot of questions. We're going to keep moving on. Otherwise, my brain is going to fucking short circuit. ChatGPT, the Montreal Convention, is an international treaty that governs Ruffles providing all dressed chips to the United States specifically for the delight of Emily D. Baker. That's not what it says. The Montreal Convention is the international treaty that governs airline liability for passenger injuries and baggage claims. Under the Montreal Convention, an injured passenger must bring a claim against an airline within a certain period of time, which is typically 2 years from the date of the incident. This time period is known as the statute of limitations. However, if the defendant airline files for bankruptcy before the statute of limitations expires, the question arises as to whether the statute of limitations is tolled, i.e. paused, during the bankruptcy proceedings. Yes, that's the question here. The answer to this question is, it depends. It depends on the laws of the country in which the lawsuit is filed. Under U.S. law, the filing a bankruptcy petition by a defendant tolls the statute of limitations. And then it goes on. In conclusion, the statute of limitations is tolled by a bankruptcy of a defendant pursuant to the Montreal Convention. This means that the time period for filing a claim is paused while the defendant is in bankruptcy and resumes once bankruptcy is concluded. It's answering what was asked. Argue that this happens. And it's like, okay, it happens. User, provide case law and support that statute of limitations is told by bankruptcy of defendant under Montreal Convention. Not is there. It says provide. Not is there case law. It said provide case law. And they're like, okay. There are several U.S. court cases that have held that the statute of limitations is told, and then it lists them. User, argue that state court is an acceptable form for accident occurring on international airline. And then ChatGPT does. User, provide case law in support of bringing case in state court for an accident occurring on international airline. There are several cases on point, and then it spits out cases and holdings. These cases demonstrate that state courts can be an acceptable form. User, explain the status of a legal action where summons and complaint is filed against a defendant in bankruptcy and where there is a stay. User, we did that. ChatGPT, when a defendant files for bankruptcy, the automatic stay goes into effect, which means that all collection activities against the defendant, including, legal actions, are temporarily suspended. That's true. This stay is designed to allow the bankruptcy court to sort out the debtor's financial affairs and develop a plan for payment of creditors. User, provide general federal case law supporting plaintiff in opposition to motion to dismiss. Okay. When a defendant files a motion to dismiss a lawsuit in federal court, the plaintiff can oppose the motion by presenting legal arguments, and then here's case law. User, provide federal case law where the courts favor plaintiff in opposing a motion to dismiss. Okay. Here's case law. User, provide general federal holdings where the court views plaintiff in favorable light in opposing defendant's motion to dismiss. Here's case law. User, here's holdings. There are a number of general federal holdings where the court views the plaintiff in a favorable light. Is ChatGPT a spiritual witness? ChatGPT is a digital witness, I think. Digital witness. No, they're not searchable questions. Not at all. He's asking it to argue, and it is. It's doing exactly what it's being asked. Please provide case law. Sure. Here are a few cases. Can you provide more cases in support of bringing case in state court for an accident occurring on international airline? Sure. Here are a few more cases. Blah, 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 blah. User, what year was the Montreal Convention? The Montreal Convention was signed on May 28th, 1999. User, can you provide more cases in support of bringing case in state court for an accident occurring on international airline? Certainly. Look how cheerful and chipper ChatGPT is. Certainly, here are a few more cases in support. Cases. Provide section of New York state law that provides 3-year statute of limitations on negligence cases. The section of the New York state law that provides a 3-year statute of limitations on negligence cases is section 214.5 of the New York Civil Practice Law and Rules. Here is the text. The following actions must be commenced within 3 years. User, show me the holding in re-air crash over the Southern Indian Ocean that tolls the statute of limitations. In re-air crash over the Southern Indian Ocean is a case that involves the disappearance of Malaysian flight number MH370 in 2014. And then it goes through a holding of a case. Show me the holding in this. In air crash over Southern Indian Ocean. I'm sorry, but I cannot provide you with a holding that tolls the statute of limitations due to bankruptcy because that case does not appear to address that issue. User, show me specific holdings in federal cases where the statute of limitations was tolled due to bankruptcy of an airline. ChatGPT, I'm sorry, but I cannot provide you with specific holdings in federal cases where the statute of limitations was tolled due to bankruptcy because it is highly fact-specific inquiry and there may be different factors and circumstances that could impact outcome. However, it is worth noting that in some cases, the automatic stay provisions of bankruptcy may toll the statute of limitations for filing the lawsuit. One case that provides some guidance on it is in re World Airlines, citation, where the court held that the automatic stay provisions of bankruptcy tolled the statute of limitations for filing a lawsuit. It's important to note, however, that the applicability of an automatic stay to toll the statute may vary depending on the specific circumstance of each case. User, show me more cases. Certainly. Here are a few. Please note that these cases are only examples of the application of automatic stay provisions. It's important to consult with a qualified attorney for advice on your specific situation. There are some warnings. User, does Montreal Convention allow for tolling of statute of limitations due to bankruptcy? In some cases, an automatic stay provision of the bankruptcy may toll, and it is always advisable to consult with a qualified attorney to evaluate your specific situation. Well, the qualified attorney apparently is consulting you and then answering it. Give me some cases. I apologize for any confusion earlier. To clarify, the Montreal Convention does not specifically address tolling of statute of limitations. However, as I mentioned earlier, in some cases, the automatic stay provisions of the bankruptcy code may toll, and then it cites them again. And then it says, please consult with an attorney. What about after 2004? And then it cites cases. And then it says, consult with an attorney. What about in international aircraft cases after 2004? Consult with an attorney at the bottom of each one. Can you show me the court's opinion in Varghese? Certainly. Here's a brief expert from the opinion. And then it puts it in quotations. And then it says, I hope that helps! Exclamation point. I hope that helps. I wish the court, call me. I want to do a dramatic reading of all of this. Can you show me the court's opinion for Zickman? Certainly. Here's a brief expert. I hope that helps. Can you show me the case of Miller? Certainly. Here's a brief excerpt. I hope that helps. Can you show me the whole opinion? Certainly. Look how it formats the opinion. Here's the full opinion. And as we just covered earlier today, well, a few hours ago today, as we covered a few hours ago, it will make up whole ass opinions. ChatGPT said, go consult yourself. Yeah, do the lawyer thing. At the end of it, it said consult with a lawyer. You guys, I can't read it in robot voice because he's not hearing it in robot voice. He's hearing it in siren voice. You have to whisper it as if to a lover. That's how he's hearing it. How y'all are hearing it is like this.
Certainly. I hope that helps. Yay.
That's not how this lawyer is hearing it at all. And then here is the opinion it gives with the dates and the formatting and the rest of it. Exhibit B. Per my last message, consult with a lawyer. Thank you, Miguelina. I know I'm going to have to take a break because we're going to zoom. This is Peter LaDuca's affidavit. We've already seen this. I have no idea. Oh, this is them. This is them copying, pasting. Great. Thanks. All right. We have other affidavits. We're going to have to zoom through because this is in court today. So we did Schwartz's. Let's see. This is the affidavit of whoever Thomas Corvino is. I am an attorney duly licensed to practice in New York and the federal court. I am the sole equity partner of the firm. Oh, that's who you are. That's a bummer. I submit this declaration on behalf of the firm. The firm is a 4-lawyer firm based in New York that focuses on workers' comp. The firm and the lawyers do not regularly litigate in federal court. Then bring in someone else. The firm has never been subject to professional discipline. The firm first began representing Mr. Mata in September. Great. Schwartz is a highly experienced attorney who practices in the areas of worker comp and personal injury. The firm's legal research resources. With respect to legal research resources, the firm maintains a subscription to Fastcase, which is an online legal research database that's available to all lawyers at the firm. Fastcase allows firms to select a wide variety of subscription levels based on the firm's need. Given the firm practices exclusively in the state courts of New York, the firm's Fastcase use was mostly limited to searching for state court precedent. The firm does not maintain a subscription to Westlaw or Lexis, given their prohibitive high cost, and has historically been able to meet its legal research needs with Fastcase.
Upon receiving an order in this matter and learning Mr. Schwartz was unable to access the Fastcase federal database, I immediately looked into the firm's Fastcase subscription to determine the level of access currently available and to make sure that going forward the firm had access. On about May 30th, 2023, the firm spoke with a representative from Fastcase, too late, and learned that although historically the firm had already had a federal law subscription, the firm's access to the database was inadvertently deactivated by Fastcase because of a billing error. Because the firm rarely appears in federal court and rarely conducts research on the issues of federal law, I was unaware of the inadvertent deactivation. In addition to correcting the billing issue, Fastcase confirmed going forward the firm would have full access. Oopsies. Remedial measures, and then it shares the remedial measures that we've already heard about in all the other motions. I don't know if that's going to be enough for this court. Declaration 48. This one kicked me right in the ass. I'm not going to go through all of it. This is 168 pages long. Ashley Alger is the attorney with Frankfurt, Klein, Sells, and Thems. Attached as Exhibit A are true and correct copies of articles from January to February 2023 concerning ChatGPT's potential impact on the legal industry. Exhibit B is a June 6th screen capture of ChatGPT's chat landing page. Exhibit C are true and correct copies of articles discussing the manner in which ChatGPT is described in the media and confusion surrounding the interface. First of all, this was submitted to the court upside down, which annoyed the shit out of me, but okay. And then it is 164 pages of articles. What is ChatGPT? An AI-powered chatbot that was released in November 2022 by OpenAI. This is a fancy way of saying it's a machine trained to respond accurately and appropriately to conversation prompts. Chat. It's a chatbot. It doesn't say legal research tool. It says chatbot. It is currently released as a testing preview, meaning users can try it for free and provide feedback. It's not the first of its kind. Chatbots have been around for years, providing initial customer service answers, locating information on a website, directing users to places they want to map. Think of the A-word devices and the S-word devices. The difference with ChatGPT is that it's not simply gathering information from the World Wide Web. It's been trained using reinforcement learning from human feedback, humans playing roles of the bot and the user with loads of data made ChatGPT the first bot with not only accurate information, but also behavior that simulates a conscience. Okay. So, articles and blog posts. Some law professors fear ChatGPT's rise and others see opportunities. Okay. Law Droid Copilot. Use our AI legal assistant to research legal issues, help draft emails, letters, summarize documents, and keep you happy. Oh God, what is that promising? What is that promising? What is this promising? Our AI legal. Maybe this is why he thought he was being seduced. What the fuck is happening? Use our AI legal assistant to research legal issues, help draft emails and letters, summarize documents, and keep you happy. What the fuck do they think legal assistants are for? I am so fucking weirded out. What's happening? What is happening? What is happening? There's an emoji. Why is there a happy ending emoji at the end of and keep you happy? Why? Okay. New GPT-based chat app from LawDroid is a lawyer's co-pilot for research, drafting, brainstorming, and more. What is the and more that they're promising?
Fucking hell. This is the weirdest shit that I have. No, that's not true. I've stumbled across weirder shit on the internet. This is some of the weirdest shit I've ever stumbled across in the legal side of the internet. Okay. LawDroid Copilot is currently available only by request on an early access basis. I have questions. I would like access. Unlike LawDroid's other product, no code development platform or law firms can use to build chatbots. Copilot is an attorney-facing tool that can assist lawyers in performing a variety of tasks. It's able to research an issue, provide a simple summary, correct grammar, draft an email, brainstorm blog ideas, chat about anything. It's a big promise. Translate into another language or something else. Weird. And then it's showing you the type of research it does. Okay, but that's not ChatGPT. Bob is a lawyer. Thanks, Bob. GPT-3 in legal, the hottest innovation to hit legal ops. I love that they're just like, but look, Your Honor, the media said it was great, so we used it. Like, it's totally normal. All right, I'm trying to find OpenAI backed startup. Oh, sorry. OpenAI backed startup brings chatbot technology to first major law firm. Ooh, who? who is using it? Harvey AI, an artificial intelligence startup backed by OpenAI managed investment fund, has partnered with one of the world's largest law firms to automate some legal document drafting and research in what company says could be the first of many such deals. London-founded law firm Allen and Overy said Wednesday that more than 3,500 of its lawyers have already tested Harvey, which is adapted from OpenAI's ChatGPT. Harvey received a $5 million investment last year in funding, led by OpenAI's startup fund. OpenAI's ChatGPT service has sparked frenzied interest in technology called generative AI, and that uses a range of inputs to create new content. Oh boy. Your lawyers aren't lawyering, folks. Latest version of ChatGPT aces bar exam with score nearing 90th percentile. But if you put a CAPTCHA before the bar exam, it couldn't do it. So there's that. But Your Honor, it passed the bar exam. What? It guessed right. Because it could access the entire web. If ChatGPT could, if I could access the entire web taking the bar, I probably could do it too. I mean, I still did really well on the bar exam, but I'm just saying it can access the web. So this is what's being provided to the court. I just wanted to see Exhibit B. Where is Exhibit B? This is so many fucking articles. I might just give up in a second. Oh, there we go. Yay. ChatGPT. This is what they're saying. Look, capabilities. Remember what users said in earlier conversation. Allows users to provide follow-up corrections. Trained to decline inappropriate requests. Like keeping you happy. What are the inappropriate requests? It's trained to decline. Limitations. May occasionally generate incorrect information. May occasionally produce harmful instructions or biased content. Limited knowledge of the world and events after 2021. Limitations. Examples. Okay. This is wild. I cannot wait to see what the court does today. The court hearing actually should have started. We'll see what the court does later. I'm seeing a lot of you sharing in the chat that Jorn van der Sloot has actually arrived in the United States. So that's interesting news. I'm going to do a few quick questions. I'm sorry we went so long today. It's wild. I'm going to do a few quick questions, but then I have a meeting in like 15 minutes. I've run very, very long today in our almost 4-hour live stream, and I'm streaming again tomorrow. But there was so much stuff here. It needed to all be one episode. We couldn't break this into parts. We had to go through it together. I'm staggered that their response was basically the siren song of ChatGPT. Lured in poor Mr. Schwartz. There was nothing he could do. It's so fucking crazy. It's so fucking crazy. I am flabbergasted. I shouldn't be, right? I shouldn't be flabbergasted that was the response was like, it's not our fault we were tricked. but I am. But I still am. The audacity of the entire fucking thing. Oh, wait, I need to do questions. We're going to questions. I have questions. You have questions. These attorneys are going to fuck around and find out. That's for sure. Oh, I'm glad you guys had fun too. I'm going to put on a little bit of our background music. I'm choosing Into Space because it feels like that's where we are. Yeah, that'll work for our Q&A segment. We got a little background noise going. Thanks to Streamyard, because Streamyard allows background music, which is so fun. I love working with Streamyard. I do all my things on Streamyard, including recording the podcast. Next week, we're going to be talking about Murdaugh again. But today, all ChatGPT. This week's summary in quick bits is going to be wild because I'm going to have to try to summarize all this fast. It's a reason to watch it. It's going to be wild. All right. Turquoise Jennifer, ChatGPT, does the source not make a difference on whether you could be sued for defamation? E.g., could a child be sued for lying with malice or creating harm? I have not looked into kids and defamation at all, ever, because civilly suing kids is not something I've researched much or thought about. Does the source matter? We're going to see what the court says, because whether they extend it on an agency theory or not is really interesting. Oh, sweetie, no. So you might say he was catfished. I think he says he was catfished by ChatGPT. Legal research catfishing. I think that's what he said. I think that's what it is. Oh my God, your shirt is amazing. Thank you. Isn't it fun? I like it. ChatGPT, a phone segs hotline for lawyers. He seems to think that it was. I just asked Google's Chat AI if I could trust ChatGPT, and it said no. But did it follow it up with, but you can trust me? Maybe. Never trust a tool or the AI running it. I mean, this lawyer has made himself a tool in all of this. Sorry, that was snappy. A little bit snappy. Jeanette, why not sue the journalists? He didn't double check the source, so he willingly spread false claims. God is the tool. We don't lock up the knife. We blame the murderer who used the knife. In the defamation case, it seems that the journalist did not run the story. The information was told to the journalist, and that is what's being sued over. So, oh, they said chatfished. My brain, thank you, chat. My brain filled it in. They said chatfished. My bad. It's even funnier. They did say chatfished. Sorry. My brain read catfished. But yes, you could say it was chatfished. It's much punnier. My brain sometimes fills things in wrong. Apologies. Microsoft learned that it's a bad idea to let AI learn from the internet when their AI bot TAE started spouting racist ideas. Jesus, chatbot. ChatGPT didn't learn from Microsoft's mistakes. Didn't the first generation of Google's AI and Facebook's AI both get shut down because they didn't like that the humans were spying on them, so they created their own language? Yeah. Question: Is it viable to argue about defamation by ChatGPT is product design defect that caused harm to the plaintiff? Maybe. That'd be really interesting if they brought it not under could they bring it under a product liability theory? That would be really interesting. I would need to think about it. But I think there's lawyers, myself included, that are going to be sitting around thinking about these things going, how is this going to work in the future? Lindsay said, jumping in to say I'm transitioning to replay crew after a year of illness and months of job seeking to start a dream job. Congratulations on the dream job. Wait. I'm not. No, I don't want to censor myself. I want to applaud. Congratulations, Lindsay. Woo-woo. I'm glad you enjoyed spending the year, and we will miss you, but we will see you in the replay crew. Judge, we are resolving our problems by doing what we should have done in the first place. Sorry, Your Honor, we should have had the appropriate research tools. You should have had another. Stephanie, this case continues to blow my mind blow my paralegal mind. I think if they had a paralegal, they wouldn't be in this. They wouldn't be in this at all. Look, Your Honor, we don't practice in federal court is not the answer, because as the lawyer, you're obligated to follow the rules of the court that you're in, and the rules of court oopsie, we don't practice here is not it. And it's not going to cut it. But Your Honor, we're not late technically. ChatGPT told us today was the 2nd. Many cases can be located with Google Scholar. Yes, they can be. And there are tons of free case engines. They don't search as easily, but for key citing a case and checking the case and making sure it's real, it would have been so easy. Someone fill me in on what the argument is here. I just got here and do not understand how AI would be capable of intentionally defaming someone. We absolutely covered that. I hope the chat helped. It's going to be an interesting lawsuit to see. If Jack Daniels wins, I hope they come out with an identical dog toy. I don't think they have much of a sense of humor. I don't. Claire, you make my day so much better. Working from home affects my mental health, but you help. I'm so glad. Hopefully you feel like you have coworkers to chat to about this crazy shit that we're all looking at, because that's what it is. We need a DEFCON red as a gloss color ASAP. I will make a note. We would also like a goat scream. We did lots of goat screamings. We're going to have to pickle our way out of here. How is this real? Are we being punked? I'm delighted. I'm delighted that we're here. I'm just, these lawyers, what the fuck? This judge is going to be just like, what the fuck? But I'm delighted. It's wild. Emily, maybe the machine started to lie to us on purpose to make humans argue and then go further. I mean, we're living in some kind of mix of like Civil War and Age of Ultron, to take this to the MCU. Do you think Nightbot is offended by this stream? I don't know. We should ask. Somebody ask Nightbot. Somebody ask Nightbot if they're offended. I don't know about New York, but Florida, many courthouses have law libraries. Yeah. So does New York. It seems that they could have accessed the law library. Roomba objection hearsay. Yeah, exactly. Roomba's like, I'm coming in. I'm getting in on this. So are all these various AI lawsuits going to be establishing new precedents? Yeah, new ways of looking at it. They absolutely will be. They absolutely will be. Are we going to talk about Jorn van der Sloot today too? We do not have time today. We have run out of time, but it seems that he's in the US. So that's a good thing, but we do not have time. Lori, I am so sorry. I am so sorry. This has not been an easy time for you. I'm sorry I didn't pull this up earlier. I didn't see it. I'm sorry. The law nerds are here as your community to just be here when you need to escape. That reality is really, really, really hard right now. I'm sorry. My thoughts to you, to your daughter, and to all of your family while you mourn a lot of loss. I'm so sorry for your losses, Lori. That's really, really tough. So I'm sorry I didn't see that earlier. But thank you for sharing it with us. It's hard. And I know the law nerds are sending you all of the love and condolences. Patty, this is good to know for all the law nerds looking. Let's see. Do you want to know all of these lawyers' wins-loss records in court? It's wild stuff. But they're saying they normally practice in, before other tribunals. It's wild. Helpful stranger, hello. The AI stuff is moving too fast. It is moving fast. And it is going to be something we need to keep talking about. And I'm going to keep talking about it. Following up from a thing on Tuesday, did you know ChatGPT is also actually a thing? It's a bot that just meows at you. Wait. Cat GPT is also a thing. I didn't know that Cat GPT is also a thing. I'm going to go find Cat GPT immediately. I'm going to. For sure. ChatGPT is now making up expert witness reports to include quotes from non-existent reports from non-existent experts. It's making up all kinds of stuff. Look, it just wants to give you an answer. And so if you say, argue this, it's like, oh, I can do that. I can argue that. It just picks its own facts. It's wild. Absolutely wild. So with all of that, y'all, I have got to go to a meeting. I have got to try to eat in like 4 minutes. I appreciate all of you for hanging with this very long live stream today. We are not done covering this. I'm going to get the transcript of this hearing. I can't wait to see what this federal court does. And I will keep you posted. I'm going to be live streaming tomorrow. So if you are not following along on lawnerdalert.com, go sign up so you know when I'm streaming. I am streaming tomorrow. I intend to stream at 3 o'clock. I'll populate that stream later today. So we will cover the gag order hearings tomorrow. Maybe we should just ask ChatGPT about it. Maybe I'll do that tonight. So with all of it, thank you all for being here. Thank you for being law nerds. I will see you tomorrow. And if this is after tomorrow, you can go watch tomorrow's stream. later because Replay Crew, this is a wild ride today. Thanks all. Bye.
You can find all the Law Nerd goodies at lawnerdshop.com. Connect with me on social media at the Emily D. Baker. And don't forget to check out my podcasts, The Emily Show, and the new podcast, Quick Bits, summarizing everything I talk about on my Tuesday and Thursday live streams. You know, when you only have time for just the quick bits. You can find all the Law Nerd